by members whose attendance at a meeting is not reasonably practical. Drew, can you state the reason that it's not reasonably practical for you to attend?
I'm in Florida at my sister-in-law's house.
That'll do it.
Reasonable. Is it up to it's up to the committee as to whether or not we want to permit the participation? Is everyone in favor of Drew's participation?
We'll let him.
Yes.
Okay, it's a 4-0. Procedures require that a quorum be physically present at the location of the meeting. We have, how many regular, we have
3 regulars.
four regular members?
We have 3.
And then us three,
And
and
an alternate.
we have to have a quorum in the room.
So you have to raise-
the 3 of us make a quorum.
So you don't, I stay alternate then?
You for the moment.
Yeah.
We will probably elevate you for
Whenever,
the
yeah.
cases. The person not in attendance and the member physically present must all be able to simultaneously hear and speak to each other. Drew, can you hear us?
I can.
All right, we can hear you. The public at the meeting location must also be able to hear the person who's not present. You can hear Drew?
Yes.
Excellent. And Drew, do you have anyone else in the room at your location?
No, I'm alone in the room.
Okay. And then the last is that the individual on the Zoom meeting can vote, but we have to do all the votes by a roll call vote so that they're individually acknowledged. All right. That's dispensed with, and we're in compliance. Let me just, in compliance. All right, the next is a public hearing. We have on our agenda tonight 5 STR cases and 3 variances. I do not know. I'm hoping, fingers crossed, that we get to all of the cases tonight. Okay?
Are we gonna be here tomorrow?
What?
Are you gonna be here tomorrow?
No. If there's a reason why we need to, conferring with the board, take any of these cases out of order, let me know, because we can change the order that they're just listed based on, the just big cases and and age a little bit. But if there's a specific reason why we need to take a case out of order, just let me know. Otherwise, we will start with case 2316.
Yep.
Okay? Drew, 2316, you're good? You have any reason to take these out of order?
Nope.
Okay. So then, okay, the secretary will read the application for the appeal and report on how it was posted.
Okay. Case 2316, rehearing of the zoning board of adjustments, March 19th, 2025. Decision is requested by Matt Johnson, Esquire, Divine Millet and Branch, PA, agent for Monica Maria McMillan and Laura Thompson, 17 Bergdorf Drive, tax map 113, lot 33, to determine whether or not to limit them to 184 short-term rental days a year, consistent with established use. I resent out notices. I posted at the post office on June 5th. The certified mailings went out on May 22nd, and I posted on the website on the 5th, and it was in the Conway Daily Sun, June 7th. And I have no issues with any of my certifieds. Good, go.
Okay.
Jennifer, move that microphone down to the other side of the table, corner of the table.
The mic.
Microphone.
Yeah, then we can move this one.
That's okay.
We'll move this one here a little.
No, you can't.
It's stuck.
No, you
No,
can't.
it's fine.
I just wanted to be sure that
We can
we
catch
got
Kate.
Yeah.
Right, yeah, and Kate, you
I'll
may have to
yell.
speak
I'll try to
louder
yell.
so that Drew can hear you and
Okay.
understand.
Can you hear me, Drew?
Yes.
Okay.
Okay. Okay, this is a case that was previously open. We are rehearing this. So in a rehearing, I will ask if any members of the board have developed any conflict of interest since we last heard this, just
No.
to be on the safe side?
No.
No? Okay. No conflicts of interest.
Drew?
And no for me.
Oh, that's right, I do have to ask you. So, yeah. And does anyone believe that there's any regional impact? Drew?
No.
Jennifer?
No.
Me?
No.
Okay, the other thing we'll need to do is to elevate Jennifer. So so that we have 5 voting members? Are you good with that, Attorney Johnson?
I am.
Okay. All right, case 2316. Floor is yours.
Thank you. I will try to be brief and focused since we've done this before. This is another of the rehearings. The rehearing is, for this particular rehearing, was limited solely to the issue of whether the ZBA has the power to impose a limitation on short-term rentals. The ZBA granted my administrative appeal, but put a limit of 184 days on this property. As I put in my motion rehearing and have articulated before the board, my position is that because this was a pre-existing use without any limitation beforehand as a short-term rental, the fact that it retained that requirement or retained that use, the use is not changed. There was no restrictions on the number of days in the zoning ordinance before it was amended, and so therefore, my position is that while it was proper for the ZBA to grant the administrative appeal, it was improper to limit the number of days that my client could use the short-term rentals to 184 days. I articulated the other constitutional challenges, but that's probably not completely germane to this case, and I'll articulate those a little bit. And there is one case that directly addresses on that, and so I'll talk about that later. So the only real issue, in my opinion, before the ZBA is whether and to what extent the ZBA, that this panel agrees with me that it was an error to put a limitation or not, and that's the issue for 2 of the 3 rehearings anyway, so including the first one.
Okay. Does anyone else have anything to say? You don't have, and none of your clients are here tonight?
No.
Okay, so it's just you.
Yes.
Okay, so we have gone through some of this previously in these hearings with regard to the zoning board of adjustments authority to be able to enforce the zoning rules and regulations of the town. The zoning board also has the authority to impose caveats, if you will, on any use that it approves or disapproves something. So it's, in our estimation and in our opinion, it is well within the authority of the zoning board of adjustment to be able to impose those types of caveats, if you will, to a approval. And this was an approval. The individual had provided information on 160 days. The zoning board of adjustment, in order to account for inaccurate documents, not able to come up with all of the proof, but had 90% of the proof, and changes in different renting habits, things of that nature. The zoning board of zoning board of adjustment, ZBA, I'm going to say from now on, it's shorter. The ZBA opted to give each one of the approved applications for these days a 15% adjustment, flexibility, which came out to 184 days for this particular case.
Correct.
Okay. There are criteria that we have, I guess, read into record before, that the STR exists without limitations. RSA 674-19 specifically states that the zoning ordinance shall apply to any alteration of use. The zoning ordinance adopted under RSA 674-16 shall not apply to existing structures or to the existing use of any building. It shall apply to any alteration of a building for use for a purpose or in a manner which is substantially different from the use to which it was put before alteration. And we've gone through different Article 1.3c of the Madison zoning ordinance allows limitations of use in the wording, any land use to the extent existing at the time of the passage of the ordinance but not conforming thereto shall have the privilege of continuing in such use indefinitely or reestablishing in use within a year of any discontinuance. We've gone through these arguments before, and Kate, can you make sure that they're in the record, in part of the record?
Well, they are in the minutes as they come
Yeah,
forward.
that they keep carrying forward for the
Yeah,
case?
in the minutes as they,
Right.
And I, just for efficiency purposes, I have no objection to the ZBA saying, for the reasons previously articulated in the minutes, they're gonna, that's, we've said these arguments, you know, you or Drew have said the same statement multiple times, so like, I'm
Well,
not.
and, you know, for consistency and clarity's sake,
Yeah.
we wanna make sure that
And this,
we're being consistent.
understood.
So with that being said, if there's nothing else from anyone in the room, all right, I can leave the public hearing piece open, but I'd like to, I don't know if we have to go through the whole findings of fact and all of that again? Or can we carry forward the findings of fact from the previous?
I don't think the facts have changed at all, have they?
No, there's no facts, there's no change to the number of substantiated days, there's no change to, you know, the conditions, it's merely
It's
your,
a legal argument.
it's a legal argument, right? So, so I think all the findings of fact remain the same and come forward. Does anyone from the board have anything?
I have a question in terms of how do we've set this new standard, how do we monitor this standard, is my question.
Not necessarily, I don't wanna say that it's not our issue, but that is a town issue, and the town will have to, now that we've done this, the town has to sit down and make sure that they have the metrics or the mechanisms in place to do what they're gonna do with regard to how they're gonna monitor it. So, it's not a zoning board
It's not, okay,
adjustments,
so that's not
it's
our,
not our issue,
okay.
right?
Oh,
Drew, you were gonna say something?
Yeah, I just wanted to make one comment, you know, reading through Attorney Johnson's comments, you know, there was an argument that, for example, the general existence of complaints on other properties is irrelevant to the specific property unless there is a similar complaint, but I just wanted to add to that actually, I disagree with that slightly. I would say this, just to reiterate a couple of points, that the board does generally have the authority to set conditions when granting an appeal. And secondly, we also are specifically allowed by our ordinance to set limitations. It says to the extent existing at the time, that's already been said. And the wording in New London Land Use Association versus New London ZBA refers to the anticipated impact on the neighborhood. And this kind of reference to the general impact on the neighborhood, you know, as a reference to negative impacts in the neighborhood by similar, so a reference to a negative impact in the neighborhood by similar uses can be reasonably used to justify an authorized limitation to a use that was previously established, that the extent that was previously established. So I can send you that wording to Kate via email, but basically I just wanted to affirm that we hadn't overlooked the fact that Attorney Johnson had denied the applicability of that statement of, for example, Police Chief King's reference in a period of 2 years to a number of violations that were related to short-term rentals. They do provide a general indication of the impact in the neighborhood, and that fits within the general authority of our board to provide limitations based on reasonable cause. That, of course, is not the only limitation, the only reason to do that, but I wanted to address that specifically.
Okay, does anybody else have any other comments?
No.
Any questions or concerns?
No.
No? Well, this will be fast then, I presume. I will close the public hearing. Or make a motion to close the public
Sorry,
hearing.
I didn't interrupt you yet.
That's okay, no, interrupt me
Okay,
because, you
okay,
know,
I don't wanna step out of turn here.
And I'll second that.
okay. Ouch.
Gotta do a roll call vote.
You gotta do a roll call. Drew, made a motion to close the public hearing?
Yes.
Yes? Jennifer?
Yes.
Yes,
Yes?
Yes,
Okay.
You yes? You yes?
I yes. Sorry. I did say it out loud, I just went by quick.
Gotcha, perfect, I'm done.
All right, so the discussion, we will vote and discuss amongst ourselves what what we wanna do. It's my assertion that Attorney Johnson is looking for us to completely alleviate any limitation on the individual, that we've placed on the individual to rent. They wanna be able to rent 365 days a year if they so choose, with no limitation, no restrictions from the ZBA or from the town. We have discussed previously that it's reasonable, in order to not affect the surrounding neighborhood adversely, to leave the rentals at the level at which they had previously existed, maintaining their ability to continue their non-conforming use, and not have by increased usage or extra usage, not have a adverse impact on the neighborhood or the town. It's not just the neighborhood, it's the town completely. Does anybody else have anything else to add? No?
No,
Alright, well, with that being said, I'll entertain a motion for us to, what's the general tenor? Are we looking at, we're gonna deny this motion
I agree.
for this appeal?
I'll move that we deny the motion based upon our previous votes.
And a second?
Second.
Okay, all those in favor, roll call vote. Drew?
Sharon, discussion first. What are we denying? I thought we were granting the appeal with a limitation.
I think you're just denying the motion for rehearing.
No, because you already had the motion for rehearing approved at the March meeting, that's why we're,
Well, you granted it and set it down for a new hearing, so I mean, I guess,
At the May 16th meeting, they granted this as a rehearing.
'Cause this is the.
right, and
So
this
this
is the
is the-
rehearing.
yeah.
Right, so during the rehearing process, what we're saying is, you're requesting, Attorney Johnson, for us to remove the limitation. And so we're denying your request to remove the limitation.
And then I just, again, yeah, you guys get to do it however you want, but just, yeah, then just maybe that, and stand by the original decision or something.
Okay, and stand by the original decision.
So deny based upon previous votes and
Basically what I
stand
said.
by.
That's fine.
Okay, no, we wanna make sure we got this
It
right.
does get a little
It gets a little
convoluted.
Yeah,
Hold
well,
on, decision,
okay, do we wanna read what the motion is, so that,
hold on, I'm gonna get the date. Decision dated May 16th.
Keep it as it was in other words.
Have we elevated Jennifer?
we
Yes.
did.
Okay, good.
Okay, so Doug made the motion, George seconded to deny.
Can you speak louder? I know it's harder.
Doug made the motion, George seconded to deny, the case based on previous votes, and you stand by the previous decision dated May 16th. That's when the
Yes.
decision was.
So I'd like it to say deny the request to remove the limitation, so that it's very
Request, thank-
specific as to
yeah,
what we're
that
denying.
wasn't
We're not,
said, but
we're
we're
not
gonna
going back, we're not going back and
Request to
denying their
deny.
ability to do the rental. We're just
Deny the request,
to remove the limitation,
Of 184 days.
remove the, I'm not
yeah,
adding that.
of 184 days,
This
and stand by
Blah, blah, blah.
the original approval.
And stand
Conditions.
by the, not previous, original decision
Decision
dated May 16th.
dated May 16th. No. The-
What did he say? I have it right here.
Well,
No,
we-
the
Which
re-
one?
That
that's,
was a rehearing.
that's a
Oh,
rehearing.
I'm sorry,
This one
sorry,
was-
which, the first one, there's
Yeah.
so many of them, I'm sorry, I'm sorry, hey,
That one's dated,
I think it's actually March 19th.
yeah,
Yeah.
it's like
you're correct, yes, I'm
Yeah.
sorry.
No, it's all right, there's lots of dates.
There's way too
a
many.
lot of dates.
So we get to vote?
Well, I'm gonna make sure she has
Yeah,
that
okay.
correct.
Yep.
Okay, George, that's your motion, George, see, I did it again.
Yeah, I know,
Doug.
we looked.
So much
all
It looks so alike.
Eat
Yeah.
some more chocolate, would you?
Yeah, right. Doug, is that your motion?
Yes,
And George, that's your second?
Yes.
Okay. All those in favor by roll call vote, Drew,
Yes,
Jennifer,
Aye.
Doug, aye.
Yeah, I.
Sharon, aye.
I,
Okay.
I'm a Scot, so I have to say I sometimes.
Arr.
Okay.
I have to
Put
read
off in
the,
front of it if you like.
does he have the
yeah.
30 days to appeal this?
Yeah, you read all that.
Yes.
Yeah. Where's the, where's the little, do you have the wording for the 30 days thing?
I don't,
Rehearing.
This is
Hold
a
on,
rehearing,
hold
so
on.
he doesn't have to come back here
Mm,
again. He's
that's
free
true.
to report from the-
So he doesn't have the
No.
ability to appeal this.
no, next would be to go to,
Next he's gotta
Next
go.
step would be the court, yeah.
Court.
With it gets a little funky when there's a decision on a motion, but yes,
Yeah. Okay,
agreed.
then
We're done.
we're done with case 2316. We'll close the case.
2317.
Are you good, Kate?
yep, we'll just put this one down.
Okay. Case 2317. You wanna read the,
Yep, 2317, hearing of the zoning board of adjustments, March 19th, 2025 decision. Is requested by Matt Johnson, Esquire, to find Milton Branch PA agent for Seamus O'Brien and Kayla Walsh O'Brien, 37 Ida Weiss Drive, tax map 109, lots 166, to determine whether or not to limit them to 115 short-term rental days a year consistent with established use. Mailings went out, certified mails went out on May 22nd, posted the post office's website on June 5th, and in the Conway Daily Sun on June 7th. And I did not get anything back on that one, so I'm good there.
okay. Attorney Johnson, anything different to add?
This case, for efficiency purposes, this case is exactly the same procedurally and the same legal argument as 2316, so, if the board obviously I can't tell the board what to do, but if the ZBA wishes to, deal with 2317 in the same way as 2316, I've made the legal argument, it's the same exact argument for both
And we would
cases.
make the same arguments back to
Yeah,
you.
Sure.
Exactly. I am
Okay.
not requesting that happened, yes.
Okay.
So-
Is there anyone else in the room who would like to say anything? Mr. Dempster, I need to swear you in.
Sure.
Do you swear that the testimony that you give pertaining to this case will be truthful under penalty of perjury?
I did.
Okay. You
Thank
want to
you.
state
Bill
your name and, yeah, thank you.
Yeah, Bill Dempster, Madison, New Hampshire, well, actually Silver Lake. There's been some changes, since this property first came before the board. And it was my thought that the board should know about this, because it have a profound effect on what that is. If we, look at the legal arguments, that was presented by the applicant's attorney, because the property always has been used for short-term rentals and that use has not been abandoned, the current owners, the O'Briens, are entitled as a matter of law to continue the pre-existing non-conforming use. That property has been rented since June 18th, 2024 as a month-to-month rental place. It was advertised in various online websites in May of 2024. If you follow the history of it, through Zillow, that property was put on the market for rental, and then it was taken off on June 18th. I live in the area and I drive through Edelweiss quite a bit to go to North Conway rather than put up with this Route 16 shenanigans. And the same 3 cars have been there for the entire year. I checked this morning and those cars are there also, again. Because of that, they've abandoned their use. Because they've rented it for a year as a dwelling unit with non-transient. And therefore, they have lost their ability to continue to rent on a short-term basis as a non-transient use. If you would like that information on those, I just printed up one. If you would like that information, you're certainly welcome to it.
Yeah, we'll need to look at it and then we'll give it to Kate to include in the case file.
Yep.
So you're, Mr. Johnson, are you aware of this? Do you have any?
My only point would be that to the extent they're doing that, I don't know whether they are or not, candidly. is that some of them are, people are doing this because of the enforcement action, because there's no final ruling by the ZBA to try to avoid being out of compliance with the ZBA, and unless until they got final decisions in their favor that they could act as a short-term rental. So I don't think it's fair to punish property owners who are gonna use their property in a different way while this process is running its course, to stay on the side of making sure that they didn't run afoul of anything. I mean, there's legal arguments of whether it's enforceable while this process goes on, but some of them just didn't wanna take the risk. I think the evidence before the board before was that it had been rented as a short-term rental before, and continuing up until June of 2024. And again, my understanding is that to the extent that happened, it was due out of an abundance of caution to try to wait for this process to run its course before deciding whether to do short-term rentals again. So I think it would be, I would not consider it abandonment when there's an ongoing administrative enforcement action with the threat of fines and penalties to the owners, and that would be the context that I would submit to the ZBA
Have
on
you,
that issue.
may I ask a question?
Yes, absolutely.
Have you had a specific conversation with the applicants about this issue?
I have not, relative to their long-term, using it as a short-term versus long-term rental
Yes.
basis.
Yes. I mean, you seem to say you weren't aware that they were doing it long-term, so I'm asking, have you ever had the conversation with them about what's going on?
That's a privileged conversation, and let me explain it this way without waiving the privilege. I have explained to all of my clients the benefits and the risks and the situation, because these are all arise out of administrative appeals, which have the potential for fines and further sanctions. But I can't get into the specifics of but I have explained to them the status, their legal rights, the legal risks, and they're obviously free to make their own decisions, but that is without, I don't know if specifically they're renting, for this particular case, I don't know that they're renting it long-term. I have no I mean,
Understand.
I'm not contesting what happens one way or the other, but I'm just saying as a context, that has been one option that has been provided to people to do something with the property while this process is running the course.
Yes, Drew.
I agree with Attorney Johnson on this point. During the time of our administrative process, we can't hold them accountable for abandoning the use if they've chosen an alternative to avoid a further, the risk of other things. So I think our action at this point would be just to put a condition on it and say that, assuming that it's not abandoned in the next 12 months, beginning the date after the date of decision. And that makes them aware that if they abandon it in the next 12 months, then they no longer have the option. So if they choose to rent it long-term, that's their decision. That's the right of the property owner, but if they don't abandon in the 12-month period, then they have the right, to start it. And I think that gets around this particular objection, but at the same time puts a date on the clock so that we know if they continue to rent it long-term, then it's abandoned, but but they also know that.
That's not objectionable from my side, that's a fair balance.
Very
I mean,
reasonable.
once this decision is acted upon,
Then the clock starts again, so to speak.
correct.
Okay. Anything else anyone wants? No? Okay. Then,
That's quite clear.
anything else from the board? No? Okay, then we will carry over the findings of fact and Attorney Johnson's arguments, our replies to those arguments that are the same basically as 2316. We'll make sure that you have copies of it, Kate. If you can't just do the cut and paste from. We're gonna carry over the findings of fact from the previous portion of the case. We're gonna carry over all of the arguments from Attorney Johnson and carry over the same rebuttals that the
So
ZBA
they just
made.
flow with the minutes.
Just-
I don't have to carry anything into my minutes, they just flow with the minutes as they've gone along. And I'm
No, this is different. This
Oh,
is,
to refer to
this
them.
is making sure that the rebuttals that we've made, that you have a copy of, you have a written copy of them. We used them last month, in the
Yeah.
case last month, those rebuttals and those discussions, instead of going through them every single time for every single case, Attorney Johnson agreed that we would just enter them into the record each time with it, so we didn't have to go through them, because there's ostensibly no difference between 2316 and 2317. So it's making sure that those pieces get inserted into the record. Correct, Drew? Any,
That's right, they need to be in the record written, but, right, we've
I need to add something.
proficiency avoided having to go through them all verbally from the record.
okay. You have something to still add?
I need to add something here. In the documentation that we just received from forrent.com is the listing for this property. In there, it says, 1-year lease and excellent credit required.
I haven't seen the document.
We'll get you a copy of it.
Well, that's, but I think that's the point, like, if that continues, then there's a legitimate issue of abandonment, because the clock is,
Has already started, Dick.
no, I think what,
If they leased it on in 2024, we are now a year down the road, and the current property renters have a 1-year lease with the property. As far as I'm concerned, the owners have abandoned the property.
But what Drew was saying
I understand.
is that because of the situation, and when you are under appeal, when you're ongoing through the process, the clock kind of stops for that.
If they had been renting on a month-to-month basis, I would agree. But they're not renting on a month-to-month basis, they're leasing for a year, which is different.
then I guess my point would be that I agree with the condition proposed by Drew, that then the 12-month clock starts from today.
No.
And if they want, and if it's their choice, right, if they continue to rent on a long-term basis and that clock runs out, then that's a different question, and that's, then they made that choice.
Well,
And-
the one, potentially having already entered into a 1-year lease, begs the question, have they already abandoned it? But
Yes.
what I think Drew was saying was, whether they have or they haven't, because of the situation where we're still adjudicating this, we're still going through the process, that process of abandonment ceases for the time being. Is that your opinion, Drew?
Put a
That
hold.
he's entitled to opinion.
Well, yeah, I think so, so let's just say in principle that they started a 1-year lease and 2 months into that we made a decision, right? Well, then there's only 10 months left on the lease. They still can resume within the 12-month period after we've made a firm decision. So I don't think the fact that they signed a 1-year lease negates the possibility that we can be quite upright, shall we say, in terms of our interpretation of law. Whether they intend to lease it for 2 or 3 years is up to them, but our decision, the fact that our decision falls after the beginning of that lease means that they will have completed the lease inside the 12-month period after our decision. So,
But our original decision fell before the lease.
But you granted the motion for a hearing, so.
And we don't have,
We did, but we didn't have any of that information.
No, but my point is, it's not all the way done, like had, that first decision would have been the final decision, but for the board granted the motion for a hearing, so it remained open until the decision today. So that's why I would submit that the 12 months should start
we
from
couldn't
today.
have granted the rehearing unless you had been active in the process of applying for the rehearing. So the point is that the administrative process didn't end with our decision. The administrative process ends with the ending of all the appeal periods.
Okay. Does everybody agree with that? I know that you
I
don't.
do not, I would like to see a lease with a date on it, to tell me when you think the clock has started, Drew. We don't know that.
I don't think it's unreasonable. If you're under threat of a fine for continuing with short-term rental, you have a property and you require an income. I'm just saying, if someone was to do something else with it outside of the parameters that are still under discussion and enforcement, that does not seem unreasonable. In other words, if they decided they needed to have some income from this property and they said, well, we can't do short-term rental, less than 30 days, so we're going to stick it out there for a year's lease, and it's going to take about a year, because obviously it was a year ago or more that this all began, then at least they're getting, as an owner, they can have their income without breaking or challenging or violating any of the conditions that are out there. I'm just being very simple here. If they keep doing it, I get it, then it's not a short-term rental. They lose their privilege of turning it back into a short-term rental. Now, whether it's June or July or even August last year, I think is kind of academic, because it's within the period of us all talking about it, going back to appeals, going to court, coming back, doing all this stuff.
Right.
We haven't actually had a final kind of done deal until possibly tonight, or not. But I'm just trying to
Depends on the
I'm just kind of
too.
coming in with the kind of idiot's guide to it, because I don't have this massive history here, and I don't have legal practice. So I don't think it's unreasonable for an owner to think of another way to draw an income from their property without violating any of the,
Other ordinances.
or discussions or legal aspects of what's going on out there. To continue to do it, different.
Right, once the process is complete,
Be
as
that
Drew
tonight
said.
or in another 6 months, I have no idea.
Right,
Then you kind of have to go, hang on a minute, you've turned this into a long-term, lease.
right.
But you are reading into this,
You're in the awkward position of having to defend both the property owner's rights and the town's
Yeah,
ordinances. And that's the whole reason we exist, is to make sure the town doesn't simply run over the property owners,
right.
but that the property owners also don't take advantage of the town. And so, this strikes me as, we're not trying to get the property owners in this situation. We're trying to do a reasonable job of the enforcement of the ordinance as the way it's written. And in this case, there's a justification for granting a grandfathering, and, whether we have a lease with a date on it or not, we put the date on the decision.
Yeah.
And that's the defining factor.
Okay. Any other discussion?
Said my piece.
No?
I've got more to say, but I won't.
No, please, say more if you have more to say.
I would like to see the owners here and listen to their own opinion that has not been coached as to what their intentions were. What we're doing now is we're reading intentions into them that we don't have the facts to support.
Fair.
So we can only go with the facts that we have in our hands, and that's where I'm coming from.
Okay,
That's fair.
I would say that we're not reading intention, we're reading facts. The fact is that they had a judgment or a decision back in March, March, that granted them approval to rent as a short-term rental for, theirs is 115 days, I believe.
Yes.
What they have done in the meantime, in order to, I don't want to necessarily say protect themselves, but another alternative for them in the meantime was that they pursued a longer term rental, whether that was month to month or a year-long rental, is irrelevant at this particular moment because they haven't gotten past the year.
They're not
So-
in violation of anything.
Not, well, they're currently not in violation of
Right,
anything,
currently,
correct?
right this minute, today,
Right.
now.
No.
So to I don't want to say haul them in here, but to bring them in here and have them, testify, if you will, as to their intention. I don't know that that's useful for us. I don't know that that helps with the decision regarding the short-term rental, because that's still what's priority at this moment. That's still what's on our docket, is whether or not we approve or deny the motion to remove the limitations on the short-term rental, regardless of what they've done. At this point, they haven't abandoned their rights to rent, okay, that we're aware of. They have not abandoned them. And at this particular moment, what is pertinent is whether or not they would be able to continue to use a short-term rental, use it as a short-term rental. If they stopped tomorrow, at the end of June, 30 days, you're done. You know, move out, we're gonna advertise it for a short-term rental again. They would have that right.
They have a year.
They have a year
From our decision,
from our decision, which was not until March,
right?
right? So they have a year from March. And that
Is
timeline
it March or today?
For today.
well, we gave them the approval. Well, and again, it might not even be today if there were to continue to be a next level, it would continue on in that year. That 1 year, can you hear me still, Drew?
Yes.
Okay, that 1 year, nobody knows when it starts yet.
Or isn't it March? Because that's when we gave them the one.
Well, we gave them that,
Yeah.
but then they requested
Uh-huh.
A
Right.
rehearing.
a rehearing.
Right.
So that moves the 1 year,
Mhm.
because again, it's still in process.
Yeah.
And so the 1 year abandonment is hindsight. Once you pass that year and you have a final decision and there's no more legal action or administrative action against the property or concerning the property, that's when you can date the year. When you're in the process, I don't think you can date the year.
Just maybe as a help to ZBA, subject to you guys doing what you wanna do. That abandonment principle, it's in the ordinance, I mean, it has a period of time, cause as you guys were talking, I was thinking about what I would do if I had to write that condition. I'm not sure you need that condition, cause once there's a final decision, be it now, 30 days, or whatever else happens,
It's in the ordinance.
the year's gonna start to run, so I'm not sure you need something in addition to make that provision apply. Again, subject to you guys are free to do what you want, it seems like a somewhat awkward condition to write.
Yeah, it's cumbersome, I think.
Okay. Is there anything else? No?
As long
Okay,
as
so
we-
really
As
at
long as we
hand,
can be clear on what it is we're actually saying when
What-
we do it.
yeah, well, and I think what we're here to decide is whether or not to grant Attorney Johnson's request to remove the limitations again. That's what we're here to decide. And all of this, while I don't wanna say it's just interesting information, it is interesting information. But at this particular moment, I don't believe that it holds any true value towards intent or purpose. It may later on, it may go back to show when the individual stopped short-term renting.
How
but
do we monitor that then? How do
Again,
we know that part?
not our
Not in-
issue.
No, but it kind of is though, because if we set down if we say what we did before, we deny the removal of the limit, you know, and call it a day. But in the meantime, we've had this additional information which we're saying, but we're just gonna ignore that, because we're gonna motion to deny this thing. Doesn't that seem a little dismissive of information given that may be pertinent to the case, brought to us by a member of the public and discussed by us?
It's pertinent in that the person has chosen another method to rent or another method to produce income, as you said. It becomes not pertinent if the individual ceases any other action and just starts to short-term rental with the 115-day limitation, if that's the direction we go. So it becomes part of the case history, and
Yeah.
it's there.
Yes.
And should there be additional action, it gets pulled back out and gets looked at and reviewed and
Yeah.
added in with all the other information. But again, in my opinion, I don't believe that it bears on the decision that we're making today. It's
Okay.
accessory information that gets kept, but it doesn't necessarily bear on the decision we're making today.
And I would think,
Well, if I might speak briefly, to answer the question, how does that get enforced? And the simple answer is, well, we live in a community and Mr. Dempster or someone else will know whether, for example, Attorney Johnson and his client decides to take this to court, which would mean that actually the date we set tomorrow becomes irrelevant because there's still an administrative process. I think that's probably correct. We don't need to do that. But if he decides not to take it to court, then we're all still in that situation that, you know, in a year, somebody could say, well, hey, they have abandoned it and all of a sudden they have started renting it again, then they can bring it to Bob Boyd's or his, you know, successor's attention and they can check it out. I mean, the point is, at the end of the day, that's not our area of responsibility. Our area of responsibility is to focus on the question that's in front of us and make a decision. And we're part of the whole system. We're not the whole system. We're a part of it. So we do our part.
Okay, thank you, Drew, that gives me some peace of mind. It still bugs me, but I'll just say that out loud. But I also recognise the fact that it is not part of what we've been literally asked to do today, and nor is it part of what Attorney Johnson has brought up for us to address today in his case. But I do want to acknowledge that a member of the public did, by invitation to do, that's why we have these meetings.
Yeah,
so
and that's why we will make it part of the record,
Right.
so that,
that's important
Again,
to me, anyway.
yeah,
It's
as we,
important.
as we go through this
Okay.
whole process, should
Alright.
there be.
All right, I won't repeat. Okay, thank
Okay.
you.
All right, so then our motion would be the same as in the other,
Yeah.
2316. We motion to deny, what, Oh.
Close your deliberations or whatever, you're gonna close your public hearing part or
Yeah,
whatever.
we can close it.
Oh. we don't, okay. You want me to close the public hearing?
We had already.
Usually you
Probably
do,
should.
but,
Okay.
you do.
Sometimes we don't, sometimes we leave it open, especially if we're going through findings of fact and there's things, but we're not gonna do the findings of fact,
Okay.
alright, so,
We're just going on the previous case.
we're just we're just going off the previous
Close
case.
the public hearing.
Public hearing is closed. Okay, all in favor?
Aye.
Aye,
Roll call vote,
Aye.
okay, everybody said aye.
aye.
All right, motion. Or is there any
Motion,
discussion?
is there any discussion, any concerns?
Nope.
Okay, that we haven't discussed.
You're right,
We've discussed a few. Alright, so then we're looking for the motion to be that we, the ZBA denies,
exactly the same wording as last time.
yeah, can you read
Numbers,
that wording?
But use these numbers and this address.
Deny the request to remove the limitation of, this is gonna be 115 days.
115.
Yeah. I'm already 184. 115 days, and stand by the original decision dated March 19th, 2025.
And was this March 19th, 2025? Yes, it was.
They were all the same
Okay.
day.
Okay, anyone want to make that motion? I'll make it. I make the motion. Any seconds?
Second.
George? Okay, all in favor by roll call vote? Drew?
Aye.
Jennifer?
Aye.
Doug?
Aye.
Aye. Sharon, aye.
Aye.
George, aye. Okay. There is, since this is the appeal and the rehearing, there's no 30 days. Attorney Johnson, you're aware that the next step would be,
I did, I'm aware.
okay. All right, and then now I close case 2317.
Just managed to lose my agenda.
Okay. Next is case 2325, Kate?
Yep, hold on, gotta write it down.
No, right, I gotta pull my folder. 2325.
Okay, case 2325, rehearing case 2325, appeal of administrative decision from Matt Johnson Esquire, Divine Millimet, and Branch PA, agent for Rishi, Saxena, and Abhishek Saha, 80 Oak Ridge Road, tax map 101, lot 6, to determine whether or not their circumstance allows for short-term rentals relating to a denial from Robert Boyd, code enforcement officer dated November 7th, 2023, as to Article 4, Section 4.6A of the Town of Madison zoning ordinance. Let's see, certified mails went out on May 22nd. Postings were done on June 5th at the website and the post offices, and in the Conway Daily Sun on June 7th. And I did get the applicants, they changed addresses. So they moved to, they were at, hold on one second. They moved to Boston. Did you know that?
I'm the last to know everything. Actually,
Well,
we deal with each other via email, so.
I received the address change from your client on March 19th and mailed the public hearing notice on the 11th, so it kind of crossed in the
Yeah.
mail, but,
They're aware of the hearing.
okay, thank you.
I don't-
That makes me feel
I
better.
understand, yes.
Okay.
Except there's any procedural mail issues, we
Yeah, they
waive them.
You're the last to know,
Okay.
I'm like, uh-oh.
Okay,
We're not going to another month just to read it. so.
no, right, just to renotice,
Yeah.
yeah, when they
Yeah,
probably got the notice via email anyway.
correct.
Okay, I will, since it's been a while since we heard this case, I'm checking to see if there's any if any conflict of interest has arisen with members of the board. Drew?
No,
Jennifer?
No.
No,
Sharon, no?
No,
Okay, and the waiver requests are not applicable. And, regional impact, anyone believe that there's regional impact, Drew?
no,
No.
no,
No. All no's, okay.
Thank you. So unlike the first two appeals, this is a motion for rehearing based on an appeal of a denial. So the first action by the ZBA was to deny this appeal. This is a property, the applicant does not have a history of short-term rental use before the ordinance changed in March of 2022. So the arguments as set forth in the motion to rehear, which I will not repeat verbatim for benefit of the board since we've done this a couple times, are all set forth in my motion for rehearing. I mean, the primary one would be my position that it's unconstitutional for the town of Madison to completely zone out the potential to have a short-term rental in the town of Madison, but I know the ZBA has already considered these issues and considered these arguments and has their own perspective on that, so I will, unless the ZBA wants to hear more about the constitutional arguments, I will stand by what I've said before and what I put in the motion rehearing, and for the benefit of the people behind me who are probably already sound asleep on these issues. So, that's in this case, that is a difference in this case, and I did wanna be clear, that was a motion rehear on a denial for that reason, so.
Okay, and there has been no changes in, no additional evidence, this is all on basically the constitutional and legal aspects of the zoning ordinance itself,
Correct.
okay?
excuse me, Mr. Johnson, was this not the case where there was a question as to whether or not they actually were vested based on the series of dates? And I think one of the reasons why we continued this case was to allow them the opportunity to convince us that the decision-making process had proceeded past the point of no return, so to speak, before the ordinance was posted and voted on.
I thought that was the Franklin case, I thought that was 2320.
That's 2320, this is 2325.
2325.
Okay, you're right.
Yeah, I know, right?
Absolutely, sorry, got the wrong one. Yep.
I'm glad someone else gets them confused. Oh. Hard.
All right, and so then, do you have anything else? Anybody else have anything? Any other members of the public have anything that they want to add? Okay. Board members, do we have anything that we want to ask?
Not
No.
if we've not got any more information
There's
than
no-
stands as before.
No, I think mostly what we want to do again is for clarity and consistency, is make sure that the minutes of this case reflect
Yeah.
those rebuttals to the arguments that Attorney Johnson has put forth, and make sure that we are consistent with that information. I don't know that I have that. I don't know that I brought those with me.
I certainly haven't.
Here on the second page, yeah, the constitutionally invalid, obviously, the legislative body has the right to land use, regulate land use. History makes the town's wishes clear, the ordinance was changed. Owners have rights, primary three being to live on the property, rent the property, sell or transfer. This is all the information, Kate, that you have in the notes.
It should be in his motion.
Not from him,
Oh,
these, ours, our notes that we drafted up,
I don't have that.
these,
Yeah,
this,
you have it last month,
they're
I
the-
can forward them to you
I don't
again.
have
We-
those.
We wrote them up last month and, they were part of the cases.
yeah, they were,
I don't have that physical document though. I have a note in here from, I was supposed to get it from Drew, but I don't have that.
well, this is what the thing from Drew is.
Okay,
So this is the same exact thing from Drew, I just printed a copy of it.
okay, I wanna see that before we leave tonight, just to make sure I have it. 'Cause
Okay,
I don't, it doesn't look familiar from here.
it's just printed in a bigger font, I think, so I could read it.
Oh, maybe that's why it looks different, I just wanna make sure I have it.
I just printed it in bigger
Okay.
things, but yeah, but it's the
I'm gonna write
same,
myself a note, check with Sharon before she
check with
leaves,
Sharon, right,
just to make sure I have it.
I mean, all we're doing here really is upholding what the town of Madison have said. I mean, this is, I mean, it's kind of like, they're just appealing against it because they don't agree with what the selectmen and the town of Madison basically put in front of.
well, and Attorney Johnson's appealing it on
Yeah,
the basis saying that it was unconstitutional to do to begin with,
Right.
which,
That's,
he has the right to make that
yeah,
argument.
absolutely.
If he chooses to do so, and should we choose to deny the motion, his motion to appeal this, then, or rehear it, well, we're not denying the motion to rehear it, we're just denying it.
Granted the motion
We're
to hear,
granted-
yeah.
Yeah, this is it.
We're just
yeah.
denying any change to it or whatever, we'll have to
Or
figure out the
not,
wording
yeah.
of it if that's what we choose to
Yeah.
do, which it sounds like, cause I don't hear anything in defense of changing this to allow them to
No.
rent short-term.
Not unless there's been something remarkable come up, like a history that we hadn't seen before.
No, there's no change,
No.
no factual change to the
No.
case. The facts all remain the same. Okay, so then,
Anyone pop
being that is there anybody else who wants to make any statements? No? If not, I will close the public hearing and let's work on the motion. The findings of fact continue from the previous case. Attorney Johnson's arguments continue and our rebuttal. Okay. So the motion would be we deny,
Are we what are we denying?
what do we do? Well, that's what I'm trying
Deal
to.
with administration.
We're upholding
We're,
our,
yeah, how about
Actually
we just, we
upholding, we're
uphold,
not
yeah.
our
denying
previous
anything.
Yes.
decision.
Yeah, it's actually a positive,
Yeah.
motion from one
We're gonna
sense.
uphold the previous decision. Was this one in March, March 19th? When was this one heard?
Zoning board of adjustment, rehearing March 19th, yeah.
Yep, okay. We uphold the decision of the zoning board of adjustment. I always wanna say
I
administration.
know.
The ZBA, we uphold the
Yeah.
ZBA's decision of March 19th, 2025.
Yes,
Thank you.
it was this
I had
year,
to think what year it was,
yeah.
on case 2325.
Do you want to state what that decision was or not, or is that
The
just?
decision denied the individual's ability to operate a short-term rental.
Right,
Applicants? Who's
So
gonna make that
moved,
motion?
I'm sorry,
You're making the motion?
I'll make the motion,
Second,
Doug second. All those in favor, roll call vote, Drew,
Aye.
Aye.
I,
Sharon, I.
Aye.
Aye. There is no appeal on this,
Correct.
therefore I declare case 2325 closed. I gotta write denied appeal. Upheld. Upheld 3/19/25 decision. I don't write it down these, I don't remember. Okay, that's those three. I believe, where's my, what did I do with my agenda?
2314.
Right. Now, these are cases we have not
Never.
heard.
No, they've been continued,
Right, just continued
Okay.
from 23.
but both were open.
Yep.
They're not.
They were open, that's why they were continued, so.
Correct.
And we renoticed both cases in June. I just renoticed them.
Okay,
Because last month they didn't get continued, so we renoticed everybody.
okay.
I think everybody was
okay.
tired last month. Last month it was 11 o'clock.
Yeah.
Yeah, it was the
Nobody
11th.
did, so we just renoticed, to play it safe, we renoticed everybody.
Well, I'm just wondering how long we believe, I'm sorry, I have the hiccups. How long we believe are these gonna be lengthy cases, or if they're gonna be,
I believe they're gonna be relatively short cases.
okay,
In other words, I have, that because they've been continued, I believe, at least for 2314, there were two questions in my mind that the ZBA had that I'm gonna try to answer.
right,
And then 2320, as Drew pointed out, there was one or two questions, and I was gonna try to answer that. So I don't believe, subject to, the difference being, of course, is the board has to come up with findings of fact. And so that's a little, that's a more laborious process in the rehearings, but the let me say it this way, the presentation from me on both these will not be lengthy.
okay. Then we'll continue and we'll do these, what I was considering was the individuals who are here for a variance, who had initiated their case last month. If those were gonna be somewhat easier to dispense with, I would take 2502 and 2503 and then take the 2314 and 2320. But if we believe 14 and 20 will be relatively, we're not gonna be here for hours doing this, then
I don't know, if we have all the findings of
we're
fact,
gonna
to accept
find
that
out.
is
Yeah, the
time
findings of
consuming.
fact usually aren't that difficult, so just takes us a couple minutes.
Entirely up to you, Shane.
Okay, well, I think we'll continue with 2314 and we'll see how it goes. We can always change the agenda, right? 2314, Kate.
Okay. All right, 2314, continued. I'm not gonna read, do I have to read all the continuations?
No.
Is everybody okay if I don't read
Just say
all?
continued originally from October 18th,
2023
2023.
to
May,
today.
yeah.
It's an appeal for administrative decision from Matt Johnson, Esquire Divine Mill and Branch, agent for Daniel Moynihan Senior, previously owned by Ryan Finn and Grace Harrigan, 43 Oak Ridge Road, tax map 104, lot 85, to determine whether or not their circumstance allows for short-term rentals relating to a denial from Robert Boyd, Code Enforcement Officer, dated August 16th, 2023, as to Article 4, Section 4.6 of the Town of Madison zoning ordinance. Certifieds on this one went out on June 5th. Postings were done on June 5th. I did not have to post them in the paper, and I haven't received anything back at all, so I'm good there.
Okay, board members will be polled to determine if we have a conflict of interest with this appeal. Drew?
No.
No,
no,
Jennifer? Doug? Sharon, no?
No.
No, okay. There's no waiver requests on,
Regional,
yeah, so there's none of that, and then,
Yeah.
is there a regional impact? Drew? Regional
No.
impact? No? Jennifer?
no.
Sharon, no?
No.
No. Okay, Mr. Johnson,
All
public
right,
hearing.
thank you. All right, so this is on behalf of Daniel Moynihan, 43 Oak Ridge Road, who is requesting relief and appeal from the administrative decision prohibiting him from engaging in short-term rentals. I would adopt out of efficiency my constitutional arguments I made in all the other cases. But from my notes and my memory, the two issues that the ZBA had issues with last time were one, who owned what when, so I just wanted to start there and just be clear about it, and the confusion will be self-evident of why, but so I'll clear that up. And so, here's, for the relevant time period, here is the history of who owned what when. Daniel Moynihan IV owned the property until June 8th, 2022. He sold it to the original applicants, who were Ryan Finn and Grace Harrigan, but then they sold it back to Dan Moynihan Senior, the dad,
A third.
Yeah.
The third.
on the 9th
The senior or
The third.
Dad.
the third?
I don't know which way, dad.
There is, yeah.
Yeah, it'll be
Okay.
the third.
Yeah, it would be, if it was the
There's no,
fourth.
the senior's dead. I
So
presume.
dad, on January 9th, 2025. So, the original applicant was Grace Harrigan, as appropriately, because she owned the property at the time. Then transferred to Dan Moynihan, the father, because he now owns the property. But, if I may approach, so the other question was, I had a statement from Dan the father about what Dan the son would say relative to rentals, and you guys don't like that very much. So, I have a signed statement by Daniel Moynihan the fourth, because he was the person that
previous
owned the property before the ordinance changed.
Right.
The data doesn't change, but,
Yeah,
you know, he signs it and swears that it's
Right,
accurate.
that is-
right,
yeah.
which is what we were asking for
Yeah.
at any time,
Exactly,
was
and
whoever
I
owned the
candidly
property before the
probably got,
ordinance.
I probably got confused between which Moynihan was on
I-
first and which was on
Right.
second.
Yeah.
And you have a sheet for
I do.
Kate, thank you.
Thank you, thank you, Tony.
I look at the tax card and they do the same thing.
Yeah, well, I did the same thing and then realized, and the only other thing, I think I provided this before, but I'll just provide it again because it's referenced in his statement. I'm just gonna provide copies, so he had some Airbnb rentals,
Yep.
so it's
So
40 to
Drew,
50.
how can Drew kind of, we should read it for Drew.
Yeah, I'm gonna read a copy, read it out loud once he's.
And if you want,
Are these identical to what was provided before?
No, this is a
I
new
believe
statement.
this was provided
Yeah,
before,
the
so,
spreadsheet was provided before,
The
this
lesson
statement is new.
Thank you.
You know what I can do? I'm gonna take a picture and I'm gonna,
or if you want me
text it
to,
to you.
I'll read it out into the record.
yeah, we
Yeah,
can
do
read it
that
into
as
the
well.
record, but
Sure
I'll also
enough.
take a picture.
Yeah, it's short enough, it doesn't
Yeah.
say, and here's this.
So Daniel Moynihan IV was the gentleman who owned it prior to the,
Correct, and so if you wish, I'll read the statement into the record.
yes,
So the statement is, statement of Daniel Moynihan IV, I was the owner of 43 Oak Ridge Road from March 2020 until I sold it to Grace Harrigan in July 2022. During the time that I owned the property, I regularly rented it on a short-term basis. Sometimes I used Airbnb, but often I rented it outside of that platform. I'm confident that I rented the property between 40 and 50 days in total each year that I owned the property. I'm attaching to this statement a chart of the times I used Airbnb in 2022, which was the only data I could locate. I swear that the above statements are true and accurate. This is dated May 20th, 2025, and signed by Daniel Moynihan IV.
thank you. Yeah,
Now, if I may ask, Sharon?
Yes,
In the first set of data, there was, also a listing of the number of nights that it had been rented. I'm not sure who provided that, but it began in, August of 2022. So that augments the record that, was from Airbnb. And
Yeah.
then it continued on through, June 18th of 2023. So is that, that's still part of the record?
That's
Is that
different,
correct?
and that's different.
That is still part of the
This is
record, but I didn't
This is
focus on that
additional.
because it's after the period of time when
this is
the
more,
ordinance changed.
Yeah.
So that's why I was focused on the time period, but, you know,
Before.
2022.
Yeah, okay, I see what you mean.
Cause this is from February to May 22, basically.
Which one? Yeah, so
This
we
one
already
we just
had
got.
this.
Yeah, you
We
already
had
had
this.
that, you just,
We already had this.
yeah, that is not
That's-
new, it's
that's-
just
yeah.
the statement is
Yes,
signed by the actual person who owned it
yeah,
when they did
which
the
is what we
rental.
asked for. Yeah.
And that's the additional evidence that I believe the ZBA was looking for to be able to render a decision.
Drew, did you get that text?
Oh, let me see.
Great, okay.
But we got people that-
I just took a picture of this statement so that he has it in front of him, so he can look at it in case he had any questions.
You say you sent it by text?
Yes,
That is telephone text.
correct.
I haven't
Is there any other contact?
There's self, oh, you know why?
You're not gonna
Back to
get
the
it
Wi-Fi.
from,
Frickin' basement.
yeah.
Anyway,
Madison, yes.
Well, that's all right, I heard the testimony, and
Right.
that's, yeah.
Okay. Anyone else have anything to say? Anyone in the public? Mr. Dempster, I'll have to swear you in,
Oh, I already sworn in,
not for this case.
okay.
Do you swear that the testimony that you give pertaining to this case will be truthful under penalty of perjury?
Yes.
Okay.
Couple points, I'll make them real quick. Same situation as we had with 37 Idlewice, but this one is a little different. This one has been completed, and it was completed, it started in 2023. So let me
Completed
hand
in-
these out for you.
Completed in terms of, when you say the same
Long-
situation?
Long-term rental
Oh,
and
okay.
abandonment.
Well, yeah, okay.
So, it's you to consider.
Thank you.
First
Thank you.
page is,
Can I have a copy?
first page is just a,
Copy of the,
the letter that was submitted by the applicant's attorney on September 20th, 2023. If you go to next page, which is Exhibit 1, there's a timeline here. And the timeline underneath those are, which are underlined, are all the references that are used. I want you to pay attention to the one in pink highlighted. The property was rented by the Finns, long-term, month to month. And I have those advertisements in that, starting in August
Oh.
of 2023.
they didn't rent the property, they rented it out.
They rented it out.
they were the landlords.
I was like,
yeah.
wait, why would they rent their own property? So,
But it
okay.
isn't though.
Property was rented on a month-to-month basis. It went from August of 2023 to August of 2024. Then the property went up for sale after that, and there was no short-term rentals going on from August 24th to January 9th, 2025, which is an additional time period. And the current owner did not rent at all.
I'm sorry, this says property for sale August 21st, 2025. We haven't gotten to August 21st,
I'm
2025.
sorry, 2024,
2024?
yeah. My mistake, I apologize.
And then in January, the property went back
2025,
to
that's correct.
Daniel Moynihan, the father.
Yeah. My contention is that the Finns already had abandoned the property, the use of that property as a transient rental. And therefore, anything asked for after that, the property can no longer be used as a short-term rental in a transient use. Because it's after March of 2022.
And change of ownership. Okay. To be
And a change of
The
ownership.
change of
Yeah,
ownership.
which is relevant, I believe.
Okay, that's my contention. This one is a little different than the case at 37 Idlewice. And I would appreciate if you consider these. I've got the key points on the back page for you to take a look at.
How do we get this to Drew? Because Drew, you can't see this, can you? You don't have a copy of this.
No, but just keep talking, I'd like to hear, what I understood was that the contention is that between the sale of the property, when was the date of the sale of the property? Was it March of 2022?
The original sale from Daniel Moynihan the fourth,
To Finn,
July
To
of,
the- to the-
July of twenty
it
twenty-two.
was July of 2022,
that was to Finn and Harrigan.
right. Well, actually, it says just to Harrigan, so.
Well, it actually was just a Harrigan.
Okay, Grace
Harrigan.
Harrigan.
They met married.
Then they,
Yeah.
okay.
Okay, so when was the first long-term rental?
August 23rd,
August of 2023,
yep, August of 2023 through
So
August of 2024.
that's the lease is for that
That's
year.
correct. And this is from Prime MLS, Pinkham Real Estate, Apartments.com, and ForRent.com.
And what was the date of the application for the, this was received in November of 2023?
I just to make a point that the cease and desist letters started going out in August of that year. So again, the
August
same,
of 2022.
That's a good
Right.
point. When
Right.
did they receive that?
in August of 2022. So again, this is the same situation where you got a cease and desist letter with potential fines and penalties, and an applicant decided to do something different with the process while preserving its right to appeal and challenge it. So I don't consider that they should be punished for not short-term renting while they challenge the decision that they couldn't short-term rental because time matches up. The ordinance had changed, enforcement actions letters had gone out, and then they rented it on a longer-term basis. So I don't believe that that could be evidence of abandonment when there's an action, when the code enforcement officer is sending a letter that's saying you can't do this anymore.
Except that were they not still from August of 2022 to June 18th of 2023, it says the property was rented on a transient basis, so they were continuing to rent on a short-term basis while they were under the cease and desist letter,
According to
Without-
this, yeah.
obvious concern. And it wasn't until August of 2023 that they then decided to go for the longer term.
Well, I guess I would say this is just words written on a page, there's no evidence that they actually rented on a long-term basis.
I have it right here.
Well, that's just a printout. I mean, what I'm saying is.
No, I know, I understand that, but I'm just saying
I'm
that,
saying this under perjury, so I don't wanna go to jail.
and this is from primemls.com
That's correct.
for 43 Oak Ridge, $2,500 a month, and it shows it as leased.
And the dates of which they occurred are circled in pink on the next couple of pages.
Yeah.
And then the last page is, I checked in 2024, and that,
But my point is, this is in the middle of the enforcement action. I mean, we're in the middle of the appeals to challenge this, so why should they be punished for?
I'm not saying they are, I'm just
Just-
clarifying,
Yeah.
don't get me wrong. All I'm doing is clarifying that they continued to short-term rent post the cease and desist letter for approximately a year. And then after that year is when they decided that they needed to
Sell the.
go to, well, the house got sold in the middle and they went to a long-term rental of a year. So
For the people who bought it and then they sold it back to someone.
they sold it to the father,
Right,
so.
and is that who's appealing, is that who's applying for short-term rental?
It started for the current, the Miss Harrigan, but then ultimately changed to Mr. Moynihan because during the pendency of this appeal process, because it's run so long, the property was sold to Mr. Moynihan.
Right, so
And he's-
he is the applicant, he's
He's
who
the
we are
current
making a
applicant,
decision
yeah.
He's
for.
the current applicant, but it was originated by Miss Harrigan
Yeah.
and Mr. Finn.
Because they owned it in that interim period between
Correct. Yes,
4 and
lots of
3.
dates,
Yeah.
sorry.
And lots of Daniels. Okay.
do you have any more questions for me? That's just, I wanted to put that out there for consideration for
Thank
the
you.
board.
Nope, and I wanted to make sure that we clarified.
Thank you.
Property for sale, that was in 2024, property not rented.
Okay, so just for my clarification too, if I understand this correctly. We have, in round figures, at least we have data that shows that the property was rented on a short-term basis, from February February 2022 through all of 2022, basically off and on short-term rentals. Into 2023, it was sold in July of 2023. Is that correct?
22.
22.
No, that was.
No, that's the,
2022 sold.
we're going back to the second
No,
sale,
so anyway,
when
it's the same, so it's the same.
Harrigan
model
sold it
going on.
back.
And then in August 2023, they went to a long-term rental, and then they applied for, the appeal for a zoning, for the, administrative, appeal of administrative decision that came in November. That was during the time frame that they were doing the long-term rental. So, I mean, we don't have to, we've got no enforcement process. I mean, it's not of our immediate concern that they were renting in that time frame, but they obviously took an action to rent long-term to obviate any problem with short-term rentals while they made an appeal. I mean, the period of the long-term rental overlaps significantly the period that they were actually in the administrative process of an appeal.
yeah, they started the long-term rental in August of 23. The letter to the Madison Zoning Board of Adjustment.
What's the exact date of the, when was this one looking for their? This was, yeah, we received the case, came in October 3rd, was the date of, Attorney Johnson's letter. So,
Yeah. There it is, October, and it was received October 4th. It's
Yeah.
stamped October 4th, 2023.
right, so they were doing long-term rentals effectively during the time of the administrative process.
Yes.
Yeah.
Well, the administrative process started after they were doing long-term rentals, is that correct?
No,
No,
because they had been notified, the cease and desist letter is from July 11th.
they obeyed
Of
the cease and
2023.
desist
Oh,
when
okay.
they went into long-term.
They were
rental.
renting
No.
since
They didn't?
23,
Well, I guess, yeah, theoretically, if you go by the date, July 11th,
Yeah,
then they
Give
started
and
the,
take a day or two.
started the long-term rental in August.
right,
August of 2023. So once they got the cease and desist letter,
they stopped short-term renting.
they
with them.
stopped the short-term
Yeah.
rental and went to a long-term rental.
Yeah, which is none of our business, basically.
Well, no, I mean,
Well, it wasn't in the last case.
no, it is our business, it just didn't enter into the deliberation
Right.
piece of it,
Sorry,
so.
yeah, wrong wording.
Yeah, it's okay.
Well, again, the question is whether the fact that they entered into a long-term rental during the period, so they got their letter in July, in August, they started a long-term rental. Okay, it's obvious that it takes a little bit of time to get their act together, to find an attorney, to get things going. So in October, we got the process going for an appeal, administrative decision. It doesn't appear to me that there's a strong case for saying they intentionally abandoned short-term rental.
Right.
I mean,
And again,
Yeah,
using the rationale of the
these
pre,
things are going like clockwork, one after the other. They stopped the short-term rental, began long-term rental, got out of the process of being in the sites of the town, found an attorney, made an appeal,
And want to go back to short-term rental, yeah.
So it sounds like what,
it went back to, didn't it? No, property,
not yet.
no.
But they have proved that they had a history of some short-term rental, so they have some history.
well, yeah, in fact, if you allow them to count that time as what they were renting, I added it all up this afternoon. In 2023, they rented 29 days for, out of the first 167, which would account for, if you were to extrapolate that for the whole year, because it was interrupted by the process. If you extrapolated it for the whole year, that would have given them 63 days for the year.
Mhm.
In the previous year, they had 57 days, which matches very closely to what the testimony was given in that letter.
Yes,
And if you average that out, that's 60 days a year. You know, very consistent, clearly
Yeah.
interrupted in, you know, in July by the letter. So I mean, this, just looking at this, if I take off all concern, if I were just looking at it with open eyes, I'd say, obviously, this is a person who took seriously the fact that they got a cease and desist letter. We have no idea whether they were aware of the ordinance change or not when they did it, or whether they thought it applied to them or not, but it's clear that once they received that letter, they took action that was appropriate.
Okay,
If I can clarify something for the record.
I was gonna say, because if nobody else had anything to say, I was gonna close the
Yeah,
public hearing and we
I
would
have
deliberate.
here, actual Bob Boyd's letter, notice of violation.
Mm-hmm.
It's August 16th, 2023. And that letter is referenced in,
Wait, August 16th? That's the
I think
second
there's a
letter.
second
There's a
letter.
July 11th of 2023 was the
this
first
is
one.
right here, notice of violation.
Yeah, but there's two letters.
There's more than one letter, I believe.
Okay,
This
this is
was-
the final one, right here.
that's the second one.
Okay.
And that is the
And
letter that
that's
is
dated, what, I'm sorry, August what?
August 16th, 2023. And that is the letter that is referenced by Attorney Johnson's letter to the board with replying back to the notices.
But the board has the original letter from July 11th, so I think that's the operative date.
I have that right here, copy.
Yeah, I can get one from
Yeah.
Kate, that's, thank you. It's probably in my packet, I just haven't. They start to get longer and longer. Okay, is there any further testimony from, or discussion?
I'm
No?
all set.
All right, if that being said, I vote that we close the public hearing. Do we have to
Aye.
vote, aye?
Aye.
Aye.
Thank you, aye, Sharon, aye. All right, so then, let's at least start with the findings of fact, which could take us a little bit.
Yes. You might wanna look at those.
Yeah,
Those
I was gonna
facts.
say, well, that and plus here, if we go back to here,
Yeah, right,
go back to the very first.
yeah.
From a chronology standpoint, the exhibit one helps us with that. That March 7th, Oak Ridge, 43 Oak Ridge property was purchased by Daniel Moynihan IV. They sold it then to Grace Harrigan in June of 2022. Okay, so
March 7th, what year?
March 7th of 2020.
Yeah, we then sold it.
The property was rented in February of 2022 on a transient basis. And those are those Airbnb documents. No, so those rentals began in February of 2022.
And went right through to May that we can see here.
They go through 6/18 of 2023.
Yeah,
Like I said, average extrapolated over 2 full years, it's 60 days a year.
What did you say in 23? 6/23? June 23?
I said, yeah, 6/18/2023 was the last rental reported.
And it was for approximately 60 days a year.
Yeah, that's, I mean,
and he
they
actually,
stopped it in June, but if
Yeah.
you're trying to figure out what rate they were using,
They
based on the fact that they rented it through previous winters at a similar rate, you know, it's fair to say it looks like approximately 60 days a year is a fair extrapolation.
and he actually made a statement saying 40 to 50, so yeah.
Yeah. Well, they have 2022.
Yeah.
Yeah,
So findings of fact.
Okay, so starting again. Number one, I'm gonna say with the property at 43 Oak Ridge Drive was owned by Grace Harrigan from June 28, 2022 until January 9th of 2025.
And in that time,
Say that again, just read that again, I'm sorry.
The property at 43 Oak Ridge Road was owned by Grace Harrigan from June 28th, 2022 until January 9th of 2025. They put it on the market in August. It was under contract in September and it looks like it sold.
closed in January.
It closed in
August
January.
August 2024, right,
Yeah, that
the wrong
says
date.
25,
Yeah,
right. He said
yeah,
it's
yeah,
supposed to be
yeah,
24,
yeah.
yeah. And then in January 2025 is when we call it sold to Daniel
Daniel
Moynihan, dad, the father. Okay, 3. Phew,
So what was 2?
2 is, I'm sorry, the property was rented as an STR from February of 2022 to June of 2023 for approximately 60 days per year.
Yeah. Okay, 3.
The property was sold to
That
Daniel Moynihan. We gotta
Senior.
call him something.
senior, senior.
I don't,
Third.
I mean, I can put in parentheses the father, because if this should go to court, the court has to understand there are more than one Daniel
And
Moynihan.
then maybe third, fourth, seconds, or
I don't know
who
what
knows,
they
there could be
are.
This
six-
has gotta be Daniel Moynihan the fourth.
Well, the fourth is the one who
a
sold,
fourth.
Back to the third.
he sold
And
the
there's a
house
third.
to
Senior.
Grace,
Oh,
right?
It
alright.
says senior. Father in parentheses.
Okay, you're right.
So, I'm just gonna put in parentheses the father,
Mhm, yeah.
Okay.
because,
Well, that's how Attorney Johnson described him, and that's as good as anything.
are you okay with that, Attorney Johnson, describing him as the father?
Yeah, that's fine.
Okay,
You want
I
court
want
to
the
say
court to
No,
be able to
I
understand.
appreciate that, but I think that works, yes.
And that was what date?
I'm getting to that. Property was sold to Daniel Moynihan, the father, on January 9th, 2025.
And was it being rented? What was the rental happening at this time?
There have been no short-term rentals since,
Recorded,
no short-term rentals reported
yeah.
since June of 2023.
That's a long time.
2 years.
But it is in the process time,
Yeah.
as Drew spoke to.
Yeah. Anything else we need to put in here
We need a fifth.
for the findings of fact?
Yeah, these are these are factual things.
well, yeah, I think the sequence is helpful to know that the last rental was June 2023.
Right,
The letter for cease and desist was July 2023.
So-
And the appeal was filed for at the beginning of October 2023. Says, if the board pleases, that's our justification for not considering that, understanding they were not intending to abandon, they were intending to comply.
Mhm. whilst the.
I don't know that I wanna
No.
make that, because that's not a fact, that's our opinion,
That's
that's our
assumption.
belief
You're
based
right,
on
that is
those.
a finding of
Yeah,
fact.
I don't
I'm
wanna put
just
that in the
thinking,
findings of fact,
that-
yeah.
Because the question was raised, do we wanna? Yeah,
Okay,
you're
so
right,
I-
we're working on findings of fact, right, we're not
Yeah.
deliberating yet.
Okay, so I have, Kate, do you have up through
No, I
number
got,
4?
I got the last rental was June 2023.
Okay, that was 4.
And no, the STRs, there have been no STRs reported since June 2023, and then Drew started in on about the last rental was June 2023, and
Well,
then I lost him on the other.
So,
one.
when he said the last rental was June of 2023, I'm just gonna leave that, that corroborates what we wrote in number 4, which is,
Right,
there have been
okay.
no STRs
Okay,
reported since
good,
June of
'cause that was-
2023. You don't have to worry about it.
Okay.
Number 5, I put that the letter for cease and desist is dated July 2023, July 11th.
Yep.
And item number 6 is the appeal letter was dated
Filed.
October 4th of 2023.
Yep, got that,
Actually, it's October 3rd, sorry.
right.
You received it on the 4th.
So they started renting it long-term before they got the letter?
We haven't written anything about long-term rentals in these findings.
No,
of
they
fact.
got the second cease and desist in July of 23, they rented it in August of
Yeah.
23.
Okay.
I'm sure they may have already had it advertised, but
Yes.
again,
Again, we're surmising and that's just.
right, and their actions for how they rent the house during the period of appeal and
They
process is, it's not irrelevant, but it's not, we can't make any any
can't-
judgments based
right.
on that.
Right, understood.
you know. And then all of this, yeah.
What is all
It's.
the?
It's just,
relevant.
it's relevant, except that it's already covered in that, there have been no short-term rentals reported since June of 2023. So this says property not rented on
Yeah.
transient, property not rented on transient basis,
Okay.
okay?
So, but do you have in the findings of fact that they began a long-term rental in August of 2023?
Not yet.
I hadn't gotten there yet, but I wasn't sure, I wanted to talk about that, is since we're not necessarily discussing their intentions and how they rent the property and what that means, I don't know that the fact that they started a long-term rental in August of 2023 is necessarily germane to the findings of fact.
Of course it is.
I mean, you all can disagree with me,
No,
Doug disagrees
I
with me.
disagree with you, I think it's.
Does anybody else? I mean, if you all disagree with me, I can put it in the findings of fact.
Well, if it is a fact that they did that, you know, I mean, how we interpret that is, like you say, something entirely different, but they did begin a long-term rental in August of 2023, which means they did not intend, obviously that's an opinion, but they clearly were not intending to rent short-term, at least in the time frame of that lease, which, you know, we've had some evidence of the length of that lease, but the point is, it's a finding of fact that they rented long-term in August of 2023.
Alright, so
But by
how about if I,
doing- But by doing that, whether they rented for 30 days or more, they were in compliance, you know, I mean, so,
Not with.
you know what I mean? If they're.
if they just didn't do anything, they were in
Right,
compliance, if they,
right, so
so,
that's why
I'm just not
why is it relevant,
sure.
again, relevant, the wrong word. Why
Yeah.
is it,
Yeah, well, maybe it's not, but
why is it pertinent to our, this STR discussion?
Right, well, I don't know
Maybe
that
I'm
it
missing
is,
something, I'm just saying it,
like what they did, how they rented it,
yeah.
yeah, I don't know that
Because
it is.
they didn't violate anything. They did more than 30 days, that's all we really ask. The end.
But,
What we choose to do with
But then they abandoned it. Because it's been 2 years since they've been.
that. But we've already talked about a previous case where we actually reached the conclusion it was not abandonment. We suspect it was made as a fiscal decision, we can't make this a fact, that it was done because they had to do something with the property and they weren't in violation by doing anything but renting it as an STR.
But if they've changed, I'm clear myself here. If they had short-term rental people there, whatever the time was, before they went to the long-term rental, and then they went to long-term rentals, was it new tenants or was it the same short-term rental people that rented it long-term?
What was a 1-year lease?
Well, but the point is, who was it that rented the property?
Why is that
Did-
relevant?
Because if they got new tenants to rent it for long-term, then the clock doesn't start again. The clock, they've already passed the 1-year abandonment clause.
But we've already discussed the fact that that 1 year is not germane until we get to the end of this process,
Right.
and we don't know where the end of that process is. So in the meantime, we have to deal with the piece that's in front of us as to whether or not, regardless of what happened sort of after this clock started, regardless of how they use the property, I mean, what are they entitled to? Are they entitled to operate it as a short-term rental, or are they not entitled to operate it as a short-term
Right.
rental? And if they're entitled, do we want to, put conditions on that for the number of days? And that's what we're considering here. The piece about abandonment, I think, will come up later when this process ends.
And if they should continue to do 1-year leases, then you'd say you've just forfeited your possibility of being an STR,
Potentially, yes.
potentially.
Right.
Yeah, I'm not,
Which brings it similar to the
last
last
case,
case.
yeah.
Yeah, and I think
Correct.
that's the way we should go.
Yeah. I think it's very similar in this
Mhm.
particular piece of this.
It's come
discussion.
about in a different way, but
Yeah.
it's similar.
And it's also convoluted because it's, three
Well,
different
you can
owners.
Look at it like this, we're avoiding the possibility of providing an abusive legal strategy,
Mhm.
which would be to threaten a fine so the person starts a long-term rental, and then you say, now you've rented long-term for a
Right.
year, so, you've abandoned the use, but, that's a bit of coercion,
Yeah.
so the point is, once the administrative process starts, then you can no longer count the clock as running on the 1-year abandonment until the process has been completed, then you can start the clock again.
Right,
They're in limbo.
I agree with that.
Okay, so given that, and I recognize you don't agree with that,
No, thank you.
Yeah.
I do want
Let's do
to
it.
sort of, you don't agree with the fact that the,
I don't agree with Doug, but I wanna
Oh, right.
recognise his.
that Doug doesn't agree with us.
And he has an opinion,
Right,
absolutely.
yeah, no.
That's why we're here, yeah.
Okay, given that then, I don't know that this point number 7, that the owner maintained a long-term rental,
Is any
is
relevant?
actually really,
It doesn't.
it's a finding of, it is a fact, and it's supported by an
If we-
exhibit that's entered into the record, so I suppose we could leave it there
As
for
long as
that.
it's dated so it's very clear that they rented
Yeah, I'll
in that
put,
period
I'll-
where they
were
may have
going through-
decided it was the best thing to do, we don't know that.
I'm
for
not
fact,
gonna
am I
make
here?
that opinion,
No, I know,
I'm
you're
just
not
gonna say
saying
the
that,
owner
yeah.
maintained a long-term rental from August of 2023 to August of 2024.
And we've already said when they got the letters to cease and
Right.
desist, so, yeah, anyone can follow that
Yep.
line of thought.
Okay, where do I have to pick up for you, Kate?
Okay, we changed it, so the owner maintained a long-term rental from August,
2023
yep,
to August of 2024.
What's currently happening now?
Nothing, apparently, I don't know. There's no evidence to suggest anything is happening, because even the exhibit that was presented shows no short-term rentals.
Well, that speaks
Well,
to
it was put on
abandonment,
sale.
No, it doesn't speak to anything.
doesn't it?
No, it doesn't speak to, we don't know that they didn't take that 1-year lease and just continue it, he didn't have
Okay,
to
fair
advertise
enough.
it, and the person just, renewed their lease,
Fair
we don't
enough.
know.
Yeah, fair enough.
We don't-
And they're still under the
They're still under
cease
the-
and desist, so yeah.
They're
so
under
the-
the cease and
process
desist, and
is
they're
still
under
in-
the process,
So yeah, so they are in limbo,
See
to
what
use
I
that
do.
phrase someone used earlier. Okay.
Okay? Do we have any other statements of fact that we need to make?
Is ownership relevant? In other words, if property change, regardless of the complexities of this, who owned it when and the family names, etc. If a property changes ownership, is there a clock that starts on change of ownership? Or is it the property that is actually regulated? Is it the property that's regulated, or is it the owner that's regulated?
It's the property that's regulated in relation to the ordinance.
Okay, so it's
So
the,
the-
it's the
the-
address.
It's the address.
It is not the ownership.
Correct.
Okay, it's a piece of land. Thank you.
Right, there's only one or two very, very unique provisions in zoning law that relate to handicapped people where variances and things run with the individual, but
Right,
otherwise the phrase is it runs with the land.
okay, thank you for that clarification.
What did I do with
Okay,
that? Okay. So we're good with the findings of fact?
Seven.
yes,
I have 7.
We have the same
I
amount.
have 7 scribbled here.
We're on the same page.
I think we're on the same page. Okay. We should make a motion to approve or deny the application and any conditions.
I would say we continue with the conditions that we've done previously.
60 plus 15%.
The established number with the
Right.
15%.
So we're actually, yeah, so we're gonna motion that we approve the application for a short-term rental,
Yes,
with a condition that it is the
not to exceed,
not to exceed 60 plus 15%.
It's about 70,
let's,
60.
let's get the actual number.
63, it's 69.
Right? Comes out 69.
Yeah, it's 69.
69.
With, yeah,
I think our precise wording should be we grant them the status of a pre-existing non-conforming use for the short-term rental under the condition it does not exceed, what did we say, 69 days?
yeah.
Yes.
Yeah.
Is that your motion?
Yeah, if you want to use that for a motion, yes,
Yeah.
that's fine.
Have you got that, Kate?
Yep,
Seconded.
right, so you
Is
second
that
it?
got
I
a
did.
date on it? As of today, you mean, so, I mean, is that activated as of now?
Yeah, because of the date of the letter, the decision letter
Right.
will be today. So we're gonna vote on the motion to grant the status of a pre-existing non-conforming short-term use.
So,
Existing, what was that?
Pre-existing non-conforming
STR.
short-term use with the
Under
condition
It does not exceed 60 days.
does not exceed 69.
69, sorry. You guys are talking about 60, so.
Oh, 60 plus 15%.
just a quick question.
Yes, sir.
Whenever you get a moment. So does that mean the clock is starting again? And if they long-term rent it for a year from today or tomorrow, then it's considered abandoned?
No, the clock does not start until the proceedings are finished.
That's what I'm saying, this is finishing the proceedings.
Well, it could be.
That's what I'm
If
saying.
there's no further action post this,
yeah.
then yes.
Yeah, that's what I'm saying.
Yeah, then yes.
Yeah.
Well, but that's right, if an appeal is filed within 30 days, then the clock is still running.
Yeah,
But if no appeal is filed within 30 days, then the clock runs out, and today is the day of decision.
Okay.
Okay, so we have a motion and we have a second. We ready to take a vote?
yeah.
Drew?
Aye.
Jennifer?
Aye.
Doug?
Nay.
Sharon? Aye?
Aye.
Aye. 4-1. So you didn't want to grant their status of a pre-existing non-conforming use? Okay, 4-1. All right, any person affected by this decision has a right to appeal the board's decision. If one wishes to appeal, one must act within 30 days of the date of this notice, the date being the day after the date of the decision. The necessary first step before any appeal must be taken to a higher court is to apply to the Board of Adjustment for a rehearing. We've already done that, so this appeal would have to go, oh wait, no, this isn't a rehearing, this is the first hearing. I get confused with the other cases. The motion for rehearing must set forth all the grounds on which you base your appeal. See New Hampshire Statutes RSA Chapter 677 for details. Board members are advised to refrain from any discussion of the appeal with other board members and all parties to the appeal until all further appeal periods have expired. The appeal is hereby closed, or this is closed. This case
Yep, I got
Okay,
it, I'll put it in there.
Yeah, thank you.
Don't worry.
2314.
2314,
Are we gonna go to the
Bring
other?
other people forward.
yeah, 2314, let me,
Around my agenda.
2314.
Are we gonna do 20, or are we gonna go to the ones that
Well,
people are sitting here?
I wanna
waiting
talk to, I wanna hear from Mr. Johnson on that, if he has any objection to us moving to the variances for the other individuals and doing 2320 last. It makes you have to sit here for us to go through those.
You know, ultimately, ZBA, I've got a 2-hour drive south, so, and I've sat through
Yeah, I
the,
think we should finish this.
I've sat through the cell tower stuff for
2
2
years.
True.
plus hearings.
That
Yes.
is
true.
That was 3
Yeah.
months, 4 months.
So,
Yeah.
oh,
Alright, then we will continue with 2320, I apologize, I know this is your second time being here and but it is only 8 o'clock, it's not 9, so
That's
you're doing
true.
better. Okay, Kate, you wanna
It
read?
started at 9:55 last time.
Yeah.
You did.
You
Yes,
did.
you
I didn't leave
I
here until
remember.
after 11, so I feel you.
We'll,
Okay.
yeah, you were.
2320.
Yeah, the other late, couple of you late too.
I put them on the floor before it was done.
All right. let's
Right,
move
and throw them on
forward.
the floor when they're done, yeah.
Okay. Case 2320, continued from October 18th, 2023 to today. Appeal for administrative decision from Matt Johnson, Esquire, Divine Millet and Branch, PA agent for Corey Jade and Cynthia Franklin, 26 Little Shore Drive, tax map 104, lot 96, to determine whether or not their circumstance allows for short-term rentals relating to a denial from Robert Boyd, Code Enforcement Officer, dated August 16th, 2023, as to Article 4, Section 4.6 of the Town Madison zoning ordinance. Certifies went on June 5th, postings done June 5th, and I got one back, but, she didn't pick it up, so there's nothing I can, she was noticed, so I'm not gonna worry about that.
All right.
Okay. Board members are polled to determine if there's a conflict of interest. Drew?
No,
Jennifer?
No,
Doug?
no,
Sharon, no.
No,
George, no. There is no waiver request, that's not applicable. And the board will determine if the application has a regional impact. Drew?
no,
Jennifer?
not to my knowledge, no.
Doug? Sharon, no.
no,
No. Okay. Mr. Johnson? Attorney
Okay.
Johnson, I apologize.
That's okay. Well, I've been called much worse. Don't worry. Thank you very much. This is application 2320. This is Jade and Franklin property. They are in, I forget where their address is.
26 Little Shore Drive.
Perfect. And so this was continued over the issue of whether they'd acquired some vested rights. I have chatted with my clients because there is no history of, or known history of short-term rentals prior to the application being, the ordinance being changed in March of 2022. They, in fact, the issue here is they bought the property in April 22. I'll pass up just the documentation I have. I have multiple copies, only one of them is notarized, but I realize I copied the copy and not the notarized copy.
I would give the notarized copy to Kate, so she has that, please.
Thanks.
It just, what it establishes just for the board, because the board had a question of whether vested rights had occurred. So they closed in April 2022, right after the ordinance changed, and they were not aware of it. They did get a room and meals tax license in starting in June of 2022 to short-term rental, but their records of they did a few short-term rentals, but not all that many of them. But they did start trying to look for the property in 2021 and started working with a lender in 2021, and then purchased property in 2022. So that is the substance of the issue, whether there was any sort of vested rights. So they did begin to do the work, and we're looking at properties and particularly targeting properties where they thought they could do short-term rentals, and there's a cutout of a letter from their lender indicating that their approval was predicated on the fact that they could use a certain amount of rental income to meet the qualifications, and then of course there was just, they were buying this property and then the zoning ordinance changed, and then so they're caught up in the mix. And so, the ZBA had asked a question about whether there were some any vested rights. I would submit that at some level, they did begin before the ordinance changed, and they closed right after the ordinance changed. And so, there is at least a potential where the ZBA to consider whether some vested rights occurred, particularly given the letter to Milestone, where it's clear that they were always contemplating short-term rentals and frankly, using that as the ability to finance and actually purchase property. And if they can't short-term rent the property, they will have to sell it, because they cannot afford it without that.
So it's purchased as an investment property with the intention of short-term
And
rental.
but not solely, they,
Yeah.
as I indicated, they use 20 to 30% of the year, they
Right.
use it for personal stuff too, so I don't wanna say it's 100% investment,
No.
yes,
But-
primarily investment property.
But a good year or so, a year before we, changed the ordinance.
No, they bought it right in April 22, a month after the
Oh.
ordinance changed.
But they were making inquiries.
They were looking in the summer of 21
Right.
and targeting properties where they thought they could, and at
Yeah.
the time, there was no limitation,
That's,
Madison on short-term rentals, but again, that ordinance changed. in March
thank you for that clarity. We never had anything for any abutters or anything on this, did we? I mean, they know about these things. Have we ever had?
Well, we've
any-
also, this information that you presented, we've had since April.
Yeah, we've known
This
this.
isn't, this isn't new.
I've seen this letter before.
Okay.
Right, I mean, and I have the copy from previously when it came to
That's
us, the
okay.
color copy.
And that's what we
That's-
have for it, but just, that's the timeline.
Mhm.
I understand there is no, I don't have anything further relative to any short-term rentals before they acquire the property,
Okay,
so.
Well, the question I have, if I may share,
yep,
is there a date when the loan was approved? Because, it would seem to me that, if they had a loan approval, for example, I mean, closing is significant, but we all know sometimes closing takes place in 2 weeks, and sometimes it takes 2 months. So if we knew that their loan was approved, for example, in December, that's before the ordinance was posted. And I would think that would be a fair evidence that they had vested at that point.
And I think when we met last and talked about this last time, you brought that
we
up,
brought that
Drew.
up and
We've
asked
already-
about it.
Yeah, we did ask for that before. I'm feeling like it's Groundhog Day. I could have sworn.
I don't have that answer for you.
That's unfortunate. I think.
Well, that would be significant. I mean, that might
Yeah.
be ground for wanting to continue it one more time. I
Yeah,
hate to do that, but,
I feel that way. I think it's
Well,
relevant.
Well, can we do it this way, cause I also have, I mean, people here wanna be heard on other matters, and
Yes.
wanna, if we are allowed to do this, I would make the proposition this way, which is continue it for one more month, but let me ask the question. And find out the information, and I'll submit it to the board ahead of time. And then you can decide whether you need a further hearing, or whether you can act, given that you've heard multiple numbers of these cases, and you can render a decision, just to be more efficient for people.
I'm not sure what you're asking, say that again.
I will, before the next meeting, I will send you whatever information I have as to relative to when the loan
Approval.
approval happened.
Right.
And you guys can decide whether,
That's pertinent or
yeah,
not.
right.
But we couldn't decide that before the next meeting. We would have to
Understood.
decide it at the next
But to
meeting.
speed things up, I'll send it to you in advance of the next meeting,
Oh, yeah, I would,
yeah.
I'll put it in your packets.
yeah, I would
Yeah.
highly suggest that.
Okay. Yeah, just send it to me, correct? My email address.
I could, yeah, so.
Okay,
Right, so then are we voting to continue the case for a month?
So
Till-
with
I'll
that
move-
specific
Oh,
information,
wait.
I'll move that we continue this case, which is
20.
2320 until the July meeting,
16th.
which is.
July 15th,
16th.
Here in the-
16.
16th?
16th,
16th.
16th.
July 16th here in Town Hall.
Here in Town Hall.
Here
I'll
in
be here.
Town Hall.
Okay.
Second.
I have a question, Madam Chair.
Seconded?
Will you take today regarding this case, or you wanna wait till the continuance?
I think it would probably be better to wait until the continuance, that way we have all of it fresh and,
Close the public hearing.
yeah,
Okay.
okay?
Who
Did
seconded?
did we get a second?
George seconded.
Thank you.
Okay, all those in favor of continuing?
Roll call.
Roll call. Drew?
Aye.
Jennifer?
Aye.
Doug? Sharon? Aye.
Aye.
Okay,
Thank you.
you're
We'll
welcome.
see the table and everyone else can get going.
Thank you, Mr. Dempster, have a very good
Thanks,
evening.
Did you get an email from me today? Did you get an email from me today?
I haven't checked my emails.
Two, actually.
Waiting on loan approval date.
Finally.
And
And then, I know, we're
then
moving
if that,
along.
if it's after or before, it pretty much gives us
Gives me more time for arts and crafts, so.
Okay.
So this is 2502.
2320, alright, we are at 2502.
This is your, oh, the wetlands one, yeah.
This is,
Yeah,
I don't even know where we were on that one.
I can start from the top if we want, cause that was at 9:55.
9:55 after our brains were exploding.
Yeah,
Yeah.
and we were all a little quick and punchy and transient on that conversation, so I'm happy to,
Okay,
and I heard Kate brought chocolate, we can take a minute.
she did, if anybody would like to take a minute and have a piece of
Anybody
Lynch
help?
chocolate,
Hey,
by
please.
all means, you want a piece?
Just throw
You
it around.
don't either, you don't understand.
You know, I
me-
should've
me
brought
and
some.
chocolate- me and
I've got
chocolate.
I've got a whole
and-
case.
I have
Do
a
you?
real problem with
Come,
chocolate.
come up
I
to,
checked
yeah,
it with Kate
approach the bench,
before, and
whatever,
she was
however you
like,
wanna come
I'm
up.
bringing
Anyone else?
chocolate.
You can
so-
tell chocolate.
Would you like chocolate? No? Okay, Kate, do you want some?
No.
Don't be
Okay.
shy, this never happened.
How about I?
Drew, we'd love to
how
get
about
off you a piece
I-
of chocolate, but we
hard-working
can't.
candle? You want some chocolate?
I have some actually.
Oh,
I gave her
you
some.
Yeah.
Oh, God.
Saving it.
Okay,
Alright,
alright, you wanna read that case 2502, Sarah?
okay, it's continued from last month, May 21st, 2025, case 2502. Variance request from Ethan and Laura Lemieux, 269 North Division Road, tax map 229, lot 6, from Article 4, Section 4.5 of the zoning ordinance to construct a two-car garage within the 30-foot buffer to other wetlands less than 0.25 acres outlined in the chart from the above article.
All right.
Don't worry about it, it's just water.
Alright,
We had a flood here a little bit ago, so.
Does he need swearing in?
we will in a minute, yeah. 2502, I just wanna make sure I have. Okay, board members are being polled to determine if you have a conflict of interest. Mr. Gentile?
No,
No.
Jennifer?
No.
Doug? Sharon, no?
No.
No, okay. There is none. A waiver request to
Regional
determine,
impact?
did we already do that part? Did we do the waiver request
Regional
for,
impact?
what?
Regional impact?
Regional impact comes after the board request, after the waiver request.
Sorry.
But because we've done STRs for so long, and the waiver request isn't,
I think we determined there wasn't a waiver
Right.
because
Right.
there is a
There's a
site
plan.
map, yeah.
because there's a plan.
I remember
Certified
that.
map.
Okay, so that's not
It's a
applicable.
proper drawing. Yeah, finally.
Not applicable. Okay, now, is there a regional impact? Drew?
no,
Jennifer?
Not to my knowledge.
Doug?
Nope.
Sharon, no?
No.
No, okay. No regional impact. All right, you were sworn in last time, correct?
I was.
So this is a continuation, so he does not need to be sworn in again.
Correct.
You have the floor, sir.
Did anybody else besides George have a chance to visit property?
I
Just
did
curious
not,
if
my
anybody's
apologies.
I
pretty
haven't
far.
even been here, I've been in the town.
That's fine. So I think I started in, Drew, do you have your map?
yes, I do.
Okay. To make it easier, so I'm not leaning over the desk, I did put mine up on a big board for everybody to see. So you're giving me time for arts and crafts here. Every time you extend, I'll get more. So I tried to color code this out a little bit to kind of establish that with the zoning, existing zoning rules, I was pretty limited to what I could build, so the property needs to be surveyed at 2 acres of buildable land. If you have poorly drained soils, you have to have that much more property of that. So existing is 0.22 acres of poorly drained soil. So I have 2.22 acres of buildable land. But once you place the setbacks on all of that, I'm significantly limited down to, visually it looks like about an acre of land in this narrow corridor because of poorly drained soils from road and abutting property drainage. So Adam Shackford and Bob Smith's property collect water to here on the road, and that drains across my property. So this isn't a vernal stream, these aren't pools, this is purely runoff from.
It's drainage.
It's just drainage.
Yeah.
It doesn't, per the map, it doesn't even leave my property. So, it just sinks into the ground there. The water table is 18 inches per the perk test, and I can attest to that by digging holes anywhere on the property. As soon as I put a shovel in, the ground's wet.
Good for your well.
Good for my well, it's 18 feet dug, even during the drought, I never was short water. So the blue line is the setbacks for the poorly drained soil. We have this big hoop in here because of this very small patch that's in the turquoise. That area, by the evidence I've shown with all the photos,
Right.
is not poorly drained. Even in the worst of the weather we've had this year, it doesn't pool water. I'd shared photos of me standing in the middle of that pool in the middle of the flood warning that we had, with the stream raging with drainage. So these are a little arbitrary on how they calculate what the space is, maybe based on elevation, because it is a little low. The soils person back in 2004 was like, oh yeah, it's poorly drained because it's low. The evidence shows it doesn't pool up water, it's not poorly drained. So if we ignore the turquoise piece, my line on your map is a little off from coloring late night, but I would be 6 feet over. If we ignored that turquoise piece, I'd be 6 feet to poorly drained. And that's to the edge of what gets damp when it's really running, but I'm really 30 feet from running water. If you, I did mark them out, I don't know if you saw
I saw
them,
that.
George, the 2 yellow tags in the woods further back. So the first tag is 24 feet, where it kind of goes over, gets moist, sure it's poorly drained. Where the water runs, I'm 30 feet from it. So those are the constraints I have. And in conversation last time, it was, well, can you put it elsewhere? And if we talk about putting it elsewhere, we'll go through the constraints. If we move the garage forward, even a few feet, I get on top of all of my utilities. So I get on top of the well line, the electric, and the propane.
Okay.
Oh, I see that, WEMP.
Yeah, WEP, and then my septic
Septic, yeah.
line is the gray over here.
Yeah.
So, and moving forward, the kitchen is in the corner here, which,
Bottom right, yeah.
which is for Drew is the southeast corner of the house, in the corner of the farmer's porch, which is kind of the yellow space outside there. So I have the property set up where I was as far back as I could to maintain some tree buffer between mine and my abutter, but have open cut enough to gain sunlight through the house. So the house is set up with a farmer's porch to do passive solar all winter. The sun's low enough to shine underneath. In the summer, the sun's high enough that it shades the whole house. If I moving the garage forward would block a bunch of that sun. But also, on a safety piece, it would block my view to my driveway.
Yeah.
I don't want people coming down my driveway and I can't see them.
Yeah.
And just have somebody show up there. I try to live a fairly analog life. I don't have bells and like, we don't
Yeah.
ring and all of that stuff, we just trust our neighbors, but I do wanna see who's coming down the driveway. So, it would force me to potentially have to move some utilities. So then the next question was, well, can you put it down on the southern part where the propane tank is? Moving the propane tank is pretty involved, and
I'm sorry, is it underground or above ground?
so the propane tank is underground there. And it's underground there because I was able to bring the height of the property up. But because the water table is 18 inches, the only spot I could put it without violating the setback from the poorly drained soil and not being on top of my water and being accessible for the gentleman who's gonna come fill it would be right in here, and that's low. So now that means digging up a tank, emptying a tank, changing the format of the tank because it's a below grade tank. I would have to put it above grade because the propane company wouldn't let me bury it because it is too low. Even here, so I'm about 4 feet higher there. I did have to put concrete anchors underneath it and chains over it before I backfilled it because they worry about that floating. So moving the propane tank does involve quite a bit of work to do it, and that's not cheap either. By the time you're emptying and moving, and they have to set me up with temporary tanks to be able to do all that work. Every time they come in, that's a service call. They have to turn off pilots, they have to refire pilots, everything has to go down and come back up, so. And that is, if I were to put it at the property setback there and put a 24 by 32 garage here, I would be 100-foot walk back to the house. Now, who puts a garage 100 feet from their house and uses it every day? So if I leave at 5 a.m. to go to work, I would have to trudge 100 feet in the snow to get to my car to get out of the house, where now I just would have a quick shovel to do. I'm constrained by everything else to put this here. So I did a little bit of, I printed off the two maps that kind of involve my neighborhood, and I just did this in between here, but I have a bunch of neighbors who have attached and detached garages, and if you drive by them, the detaches garage that are greater than about 2 or 3 car lengths away from the house, they don't use it.
Yeah.
Mr. Aruda has the furthest away as anybody in my neighborhood, and he doesn't use that garage. They park in the driveway because it's close to the house. He doesn't. Anybody closer to that is using their driveway, using their garage. So I'm just hoping that I have the same opportunity to put a garage close enough to be useful and not just be a barn on the other side of my property I look at and have to shovel my car off every time I go out to it. As far as it affecting the rest of my neighbors, it's the most central, it would be the most central located building in the property.
Yeah.
Has no effect on anybody else. It does bring my property value up, so when you're doing assessments, I would just be increasing the comp rate of the people around me anyways. I think I hit all the points that are on the sheet.
To get the garage to be stable on grade, you're gonna have to, I mean, the land is sloping away.
Yeah.
So you're gonna be lifting, you're putting a slab down or.
Piers?
No, I'm
Piers.
pouring a full walled foundation, so
Okay.
it'll have a footing. To build it, I'll have to scrape topsoil, but from my experience, building the house, as soon as we scrape topsoil, the footing's going right there. Partly, like I couldn't get the house any lower, I would have liked to, but the water table is this far underneath my floor. I wish I went a little higher, it would have made things easier. But it will have a footing at grade, it'll have a 6-foot concrete poured foundation. So that means I do not need to do much more to, I don't have to move dirt northward much, and so the building is 24 feet from the water. I might have 4 feet of sloping, I'll still be 20 feet away from drainage, it's not even a vernal pool, so. I'm not gonna build a huge mound and put a slab on it, I'm gonna
Okay.
contain the work. And because it's a driveway side, working with a smaller backhoe, I don't need to be back here in that sensitive
When you're
area.
plowing,
I can
yeah.
do all of my excavation work
From
from
the front.
here.
From the, right.
And this is my dad and I doing it. My dad laid pipe for 25 years of my childhood. The man is a genius with a piece of equipment. If we need to get somewhere, we'll get there. We can be sensitive, we can set up silt fence, we'll do it the right way, but we're not gonna be back there mowing around with a bulldozer just pushing stuff to get out of the way. I'm not even gonna stump any of this stuff, I'm gonna clear some trees to protect the building, stumps are staying. And the rest of the property's been logged a whole number of times, there's mounds and stuff everywhere. It'll give things for the kids to jump off of. I'm doing as little impact as possible to get it in there, cause I do understand that I am within poorly sensitive soil, so.
So the obvious question I have is, there's a big square spot in south of your house, between the house and your septic, your leaching field. Couldn't put it in there?
The house the living space of the house faces that way.
Okay,
South,
So
yeah.
it'd be in his front door.
It'd be my front yard.
okay.
Yeah.
Okay,
Plus, I don't,
good
well,
question.
the leach field's down there. I don't
Yeah,
think you
and
wanna-
so when
That's
you
fine.
construct, yeah, you would need Schedule 80 pipe to drive over it, and so that would mean I have to pull up the septic supply
Yeah,
line and
yeah.
change it from Schedule 40 to Schedule 80 to drive over it.
Gotcha.
Or go all the way around the house to come down.
So yeah, I'm wooded there and it drops off, so where the 102 contour line is
Yeah,
a stone wall there to contain the dirt I brought the property up with.
Yeah,
Well, okay.
so you've done your due diligence to see
I,
where it could be, and now it's like, how can, can we discuss the variances that would be needed to let you do that? Okay.
Drew, you didn't see any of my hand moving and waving, do you have any questions about the map?
No, it's a pretty obvious, what your descriptions were clear, and I saw you, the first round, so I'm pretty clear on what you were discussing, so.
Okay.
And I understand your arguments for putting the garage where it is as opposed to at the other end of that driveway T, et cetera, so, yeah, I mean, I grasp your argument there.
Yeah.
Okay.
anyone else have any questions?
What's the specific variance we're actually,
It's the distance from the wetland, where's the,
30 feet? Oh, Article 4, Section 4.5,
yeah,
construct two-car garage within
Within
a
30-foot
30-foot buffer
buffer.
to other wetlands less than 0.25 acres outlined in the chart. Yep, okay.
So the above chart was just, under 2.25 is 30 feet,
Yeah,
then 50 feet and 100 depends on the volume, the area of the poorly drained soil.
okay.
So I snuck just under the line for 30 feet.
yeah.
Gotcha.
It's a nice piece of.
George likes where it's gonna go.
Oh, I do,
So, tell me, you had
Yeah.
a chance to go out and see
I
it,
did.
talk to me,
Uh,
talk to us.
I mean, following his driveway, seeing what he's done with his house and where he's positioning that garage, it's the ideal place.
Ideal from,
Aesthetics or ideal
Well,
or
engineering?
from all of the above,
All of the above.
aesthetics,
Like, as he
utility.
explained that,
Yeah,
it just makes a total amount of sense.
and
You
the
can't-
land beyond it, where does it ultimately go? Where does it go as you go north there? What happens there?
So on a map behind
Yeah.
you, my property is, where is High Street?
There,
So Hedgehog Hill, so
Yeah.
my property is
that,
in here.
yeah,
And so beyond me, everything flows from Adam Shackford's driveway
Yeah.
north
Right,
to the
slopes
bottom of
downwards.
the road here and runs back towards this pond.
Gotcha.
And then my drainage, according to surveyed maps, disappears from, it just
Yeah,
soaks
it
into the
seeps,
ground.
yeah.
So it's
Yeah.
not running, it's refiltered by earth because it's not running
It's
stream
not
back to
going
here.
straight into a
It's
pond.
just a,
Yeah.
it's
Gotcha.
just the low spot
So
that it
you're not
runs.
running into a pond.
And it's
No,
all-
and on the wetlands stuff over here, I'm not anywhere near it on that map or those
Okay.
maps either, so.
Okay,
You've
thank
got
you.
all sand.
It's, yeah, it perks pretty quickly. Yeah, it just kinda disappears back there.
I know how it is.
Okay, do we have any other questions or concerns?
I'm quite happy.
Alright, cool. Drew, do you have any other questions or concerns?
No, I didn't see that last, explanation, but, no, I don't particularly have any questions.
Okay, then I move that we close the public hearing.
Is there anyone here that wants to speak?
Oh, is it, I was gonna say, there's nobody here.
No, you know.
There's nobody
I
left.
know.
Yep.
Okay, alright. And we'll start to talk about findings of fact. Alright, let's see. The property at 269 North Division Road, Silver Lake, is 2.22 acres, of which approximately 0.22 acres is considered poorly drained. Right,
Yeah.
applicant seeks to erect, it's 24 by 32?
Correct.
24 by 32 foot,
Single story? 1.5?
sort of single in a loft kind of thing.
Yeah,
Yeah.
it's 12-foot walls with a
Garage.
10-pitch roof over it.
Okay,
Yeah.
Yeah.
32 foot garage. Approximately, how many feet is that from that? It's 6 feet?
It's 24 feet from the edge of that poorly drained, which is measured very accurately. That's pretty easy to find that
24
spot.
feet from poorly drained.
So it's the northeast corner would be 24 feet from poorly drained.
So we're 6 foot into the drain.
Yeah, the
Yeah,
corner,
so you're only 6 feet into the poorly drained
Right.
soil.
correct.
Yeah.
Of the building, it's not the building is all that, it's just that bit of
Just
it.
a
Just that
small
corner.
Yeah,
Right,
just a
yeah,
corner.
yeah,
Yeah, yeah.
Yeah.
It's a nip of it,
And
yeah.
I'll put,
Yeah.
making the corner
A 6 foot corner.
6 feet into the required buffer,
Yeah.
setback.
Yeah.
Okay,
It starts to
Did
put
you-
it into perspective when you start talking about it.
Right.
Yeah, too, yeah.
okay, did you get that one, Kate?
Applicant
Applicants,
seeks to erect 24 by 32 garage approximately 24 feet from poorly drained soil, making the corner 6 feet into the required setback.
there you go.
Perfect.
I think the applicant has done his due diligence of where on his property
I do
is
too.
the
I think he's
most
proved,
appropriate place to build it.
I agree, I think he's proved due diligence.
So I think we say something to the point of that the other
There are no other viable locations.
areas
Are not suitable.
This
They're
is
not
the,
convenient.
Well,
Well, it's
the
not just,
convenience
Well-
is, yeah,
they interfere with water and electric and,
Correct.
and propane
Yeah.
and
Kill it.
leach fields and septic tanks and,
They're not appropriate. I mean,
Right.
Yeah.
I was gonna say, but I was gonna try and say something
A little more technical,
like
yeah.
other areas
Location,
do not present
viable options,
viable alternatives
okay. In other words,
due
other options
to-
have been considered but do not provide. You know, he's done his due diligence to look at alternative locations.
Alright, so we'll put other areas were considered but do not present viable alternatives due to,
You don't have to say due to it.
No, just full stop, yeah.
viable alternatives, period.
The other areas,
Other areas were considered but do not present viable alternatives.
Mhm. What else?
Drew, we have to go through the 5 reasons for granting a variance and make sure we meet them all?
Yeah, I think so.
Yeah,
I mean, you can base them off the application, and if they're acceptable, you don't have to elaborate much more than that.
okay. So the facts, literal enforcement of the provisions of the ordinance would result in an unnecessary hardship. I think we've discussed that based on there are no other viable options. Any viable option would result in
In
Some
hardship,
sort of-
Well-
significant hardship,
significant
applicant.
issues, yeah.
yeah, I think it would be provide hardship to the applicant.
Okay, all setbacks are marked, okay. Owing to the special conditions, no fair and substantial relationship exists between the general public purposes. Yeah, I think the specific application of the provision of the property, he did everything he could to kind of centrally locate everything
Yeah.
too as well, kind of the center of the property
Yeah.
within the boundaries of it all. The proposed use is a reasonable one, yeah, the variance allows for a garage, the ordinances allow for a garage to be built on your own property.
It goes quite
He's
good.
not interfering with anyone else.
Nope,
Variance will not be contrary to the public interest,
nope,
okay. Doesn't affect any surrounding public or private property.
no,
Spirit of the ordinance will be observed, the garage is being placed as far away from sensitive soils as possible.
yes.
You did a really good job answering these.
I think he should apply to be on the ZBA, what do you think?
Seriously?
Yeah.
Got my vote.
I
I
was sitting
think
there
he's a
thinking
strong
that.
candidate.
I was
Yeah.
gonna oppose it, but I know
That's-
he's busy.
Then Jim Shackford caught me filling potholes in on the road. He's like, I think you should go for that. I was like, I don't have time.
Yeah.
I got 3 kids and full-time work and everything else,
Yeah,
but
yeah.
I'm just sick of hitting this pothole.
Yeah, and I think the placement of the garage where you propose it does not affect the surrounding property's values
No.
in any way.
Other than to the benefit of them, quite possibly, but.
Right, it's gonna affect your property value, because now you've got another building. And granting the variance would do substantial justice, because you'll allow the garage to be built. Home becomes more usable, you don't have to walk forever to get to your garage and your
With a
car.
shovel.
You don't have to clear off your car.
Right, it is very nice having your car in the garage, okay.
So do you
I
want me
think-
to just cut and paste?
Yeah, I
these
think you just
into
copy and paste,
the-
and I don't think you have to copy and paste the whole thing, I think you can take probably the first line from each one of them, I think he does a very good job,
First line
for
of
the
each,
first line of each one of
the first sentence, you mean?
Yes, I'm sorry, yeah, the first
Yeah.
sentence.
First sentence only.
Okay. Anything else? Does anybody have any other issues or concerns or comments that they wanna make?
I do not.
You do not? No? Alright, if that being said, we would like to make a motion. Do we, any other, Drew, you have any other findings of fact that you wanna see covered, just in case, anything to add?
No, I think, No, I think we have adequate
Okay,
information and, yeah, let's go for it.
okay. A motion to approve,
Grant.
Grant.
grant, sorry, yeah,
Drew and I are in sync with there.
grant,
The application.
the
The
request,
variance request.
grant the variance request.
Yep.
For a 24 by 32 foot garage
Located per application.
located less than, do we wanna get specific, you wanna keep it at 24
No.
feet, or do you wanna keep it? Cause then if we say just less than 30 feet, he could, not saying you would, but
Just say 6
could
feet.
end up going,
Yeah,
Just say 6 foot. 6 foot into the wetland.
well, he
Oh.
may end up with 6 inches more of that, you know how that goes, you dig a hole and the hole gets, yeah.
Not my holes.
Well, yeah,
his hole is precise.
It's measured to
somehow I
every
can't do that.
centimeter.
Drew, any
It's
any
a lot more
recommendations
straight
for how to
from the
word
front of the
this?
house.
That sounds like a personal.
So what did you come up with?
So-
Estimated 6 feet or approximately 6 feet or 6 feet or?
The
How about it?
24 by
As
32
described
garage
in the,
located less.
As
Right.
described in the application.
I wrote, grant the variance request for a 30, or 24 by 32 foot garage located less than 30 feet from wetlands.
Or as described in the,
I put as
Or is described in the application.
I like
And
that.
as
Do you wanna put a more than 22 and less than, or
Like,
you could nail me to the back.
oh, we can, I
Yeah.
just, do we,
Do we want
I'm
to?
trying to keep him from,
Do we-
I'm trying to keep somebody from saying you granted a variance to be less than 30 feet, but you didn't say he could end up being 1 foot now from the wetlands. So I'm trying to give him that parameter, and I'm trying to figure out how best to describe that parameter. We want him to stay as far away from the wetlands as possible, as feasible for building purposes, but still grant you the ability to do what you have to do to put the garage in where it needs to go.
So maybe we could say up to 7 feet into the,
Up to 7 feet into the wetland buffer?
yeah.
yeah,
Or as described in the application.
Which just says 6 feet, cause
Yeah.
that's
Right.
what I did, but
Yeah.
Yeah.
I'm gonna do my best to run the line
Sure.
straight
Yeah,
through the
yeah,
house, like I wanted it right there, but yeah, it does.
Up to 7.
okay, give him another foot.
Located
up to 7 feet.
up to 7 feet into the wetland.
The corner of it's only though, not the whole damn building.
Wetland area.
That's in the finding of facts.
The poorly drained soil
Doesn't-
That's, I
area.
think that sounds
Yeah.
better,
Doesn't need to be in the
yes.
motion.
Drained soil area.
Okay.
Okay.
So, grant the variance request for a 24 by 32 foot garage,
Located,
the corner of which,
the corner, you're changing it.
sorry,
Corner.
Northeast corner.
the northeast corner of which
Fair enough.
is located
7.
up to 7 feet into the poorly drained soil
Perfect.
Area.
area. Okay,
Group effort here.
so moved. Anyone want a second?
Second,
Okay,
Yay.
we'll roll call
Roll
vote.
call,
Drew,
yeah.
Aye.
Jennifer,
Aye.
aye.
Doug, Sharon, I,
Aye.
George, I. Okay,
I want a picture of it when it's done.
Yeah, I'll be glad to show it. Thank
any
you.
I might come and see it being done.
Any
When are
person
you gonna
affected
start?
has a right to
I'm
appeal.
gonna start cutting trees on Saturday. So.
I have to read
We've
this,
just had
I have to
30.
read the appeal thing.
Sure.
So, any person affected has a right to appeal the board's decision. If one wishes to appeal, one must act within 30 days of the date of this notice, the day one being the day after the date of decision. The necessary first step before any appeal may be taken to a higher court is to apply to the Board of Adjustment for a rehearing. The motion for rehearing must set forth all the grounds on which you will base your appeals. See New Hampshire Statutes RSA Chapter 677 for details. And the board members are advised to refrain from discussing the details. Okay, anything else? Case
Closed.
closed.
Doesn't happen often, but here we go.
Yeah.
I'll keep an eye on it.
Yeah, and
Gretchen Arnold's my niece.
I was gonna say,
What's
while
that?
I know you're not going to appeal this decision.
No,
um, That's formality to
Gretchen
let
Bell.
anybody who's watching this.
those are the only butters I don't know.
Yeah, they're on, they're just down the way on the, what's the name of the road now?
Okay,
Okay.
So,
Prune
one of
that
Shackford's,
up
Yeah.
to 7 feet into
Deer Drive,
wetlands.
that's
Okay.
just beyond you to the right,
Oh, yeah.
yeah. So, all right,
Thank you.
good.
All right,
Good
we are
job.
on to 2503.
I'm gonna be polite and I'll sit and listen to you, cause I may have some evidence.
I'm gonna be polite and stay. Is that what you said?
Maybe he's thinking about it, you know, maybe
Good
he's
guy.
thinking about, maybe he'll
No,
be a
I'm
member.
all right.
Oh, there you go.
I can't.
You
I
can be an
can't
alternate.
more
You
talk.
start as
We're
an
in it
alternate.
together here, so-
It begins like this.
It begins like this. You start as an alternate and then
And then
next
you're a
thing you know.
member, but you're never an alternate, you're actually on board every time. I don't think I've been an alternate once.
Shh, don't tell them that.
I hang out with Jake Martin enough.
Okay, Kate, you wanna read the application, please?
Yep. Case number 2503, variance request from William and Patricia Brunel for property located at 8 Idlewice Drive, tax map 109, lot 15, from Article 5.9, section E and F of the zoning ordinance to permit a 10 by 12 foot storage shed, which is 63 feet from the center of Burn Road, and the setback requirement is 65 feet. All of the setback requirements are met. Also permit a 12 by 20 metal carport, which is 13 feet from the side boundary. Setback requirement is 20 feet. All of the setback requirements are met. This is a single carport, that's what that is. And in your packets, he gave me a copy of, the packets had a copy of a tax map that he dropped off after he submitted the application, just so everybody has that.
Yep.
Okay.
Yep.
Postings, hold on. I went off topic. All certifieds are gone and back, and I'm good there. And they were done, they went out on May 7th, and all the postings are, it was posted in the paper, and it was posted at the town halls, and everything's good, we're good to go.
Okay. Give me a second, I just gotta,
We did them back.
2503. Okay, board members will be polled to determine if there's a conflict of interest. Drew?
No,
Jennifer?
No,
No,
Sharon, no.
No,
Okay. No. Review and act on waiver request. There is he has a certified plot plan,
Yep.
isn't that right? So
Yep,
that's
it's
not
here.
applicable. We don't need a waiver, it's
Right.
there. And the board will determine if the application is of regional impact. Drew?
no,
Jennifer?
no.
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 Okay. Now let's pull you apart. Let's see. Pull the application apart, not you, sorry. Okay. The floor is yours, sir.
Swear me.
Oh, yeah, I gotta swear you in. Stand up. Do you swear that the testimony that you give pertaining to this case will be truthful under penalty of perjury?
I do.
Can you state your name and your address, please?
William Brunel. Current address is 1 Burn Road. It has been changed from 8 Edelweiss since the application was put in.
Oh, that's
Per
right, you
request
talked
of the
about
town
that.
selectmen.
Yes, you did talk about that, yep.
Wait, so that property is no longer called 8 Edelweiss Drive,
Correct.
it's
It is
now
now
1
1
Burn
Burn.
Road?
Correct.
Oh, interesting.
Wasn't that the post
But it's
office
still
or
part of
something,
Edelweiss.
you guys?
Yes, it's still part of it. The house
They
is still
just
in the same
moved
spot.
Moved it
I
from,
didn't move the house. no.
Didn't move
they
the
didn't move the
house.
house, they just moved the front of the lot for postal reasons, from Edelweiss
Right.
Drive to
Actually, for
Burn.
the 911.
For 911,
Oh,
yeah,
Correct.
okay,
All right, thank you.
that helps. So, talk to me about your,
Okay.
talk to us.
So, I'll give you a little bit, a quick background. My wife and I, Patty, lived in Stratford, New Hampshire for the last 27 years. Had the big house with 6 acres of land, 2-car garage, loft, all that for 3 boys. They've all grown up, moved out, we needed to downsize. We looked around, the property that we bought at 8 Edelweiss, now 1 Burn, fit the bill perfectly for us. Basically, we were looking for one level living. Patty wanted to have the washer dryer upstairs, so she didn't have to do stairs anymore, due to her knees. So what we're looking to do, when we moved in, I did not look into ordinances for putting in a storage shed, or carport or anything until after we bought the house. Then when I went to put in start looking into the need for a carport, need for a shed, I went to see Bob Boyd and found out that, we have the variance, the setback boundaries that we needed to meet. From my understanding, the setback boundaries for the town of Madison are really based off of a 2-acre lot. Where we are is, we have a .46 acre lot. So probably the best way to really approach this is, we're asking for 2 items here. One is a carport on the upper area by the front door, and then a storage shed down below. So which do you want me to explain first?
Your choice.
Okay, we'll start with the shed. So I provided pictures.
Yeah.
This is a picture of where I've outlined the shed to go. Originally, if you look at the picture, you'll see my red car and my trailer. That is originally where I had envisioned putting a shed, a storage shed. But that was too close to the property boundary and too close to the road. So, in talking to Bob, getting all the facts of what the requirements for the setback, I ended up having to move it closer to the house so that I could try to meet the setback as best I could.
Okay.
I was able to meet all of them except for the northwest corner of the shed is 63 feet from the center of Burn Road, and the setback requirement is 65. So I'm 2 feet short of that boundary.
Northwest corner, you said?
Northwest corner, correct.
Yeah,
It's to the left of the house,
yeah.
as you look at it.
Okay. Yeah,
Okay.
finding which picture on which.
That's fine. No,
That's right, that's in here. I saw it when I was going through it originally. Here, there it is.
Okay, good.
It's on the opposite side of it.
yeah. And the shed is what
So this
size?
10 by 12.
Okay, thank you, sorry. And then
In the placement of the shed, trying to meet the as best I could, the setback requirements. I can't move it back that extra 2 feet because of the stone wall behind it,
Yeah,
the retaining wall. I need to have a little bit of a gap there to be able to, get behind it and do whatever I need to do. So that's really where I'm limited to that position. That's why I'm 2 feet short on that one far corner. The Burn Road kind of curves a little bit, and it's that curve that got me. When I went to the other corner, I was good. It's just that slight angle, based on the best I could determine the center of Burn Road.
What's in here, mister?
So that
What's
is,
this grassy part?
yes, so that's a upper level with a retaining wall. It's just grass.
It's just grass?
Yeah.
And your boundary line is
Oh, okay.
farther
Good.
behind this second wall?
Yes, do you see,
I'm looking-
my boundary line is actually
Yeah, I'm looking to see.
right on the upper stone wall that you're looking at.
That's right, boundary line's right here.
So,
That's his boundary line.
that doesn't.
That's his upper ceiling wall.
Yeah,
Those upper boulders are
Yeah.
basically the boundary line.
yeah, gotcha.
Okay, I'm tracking with that, just in case anybody's wondering.
So in consideration of, I think what you're about to ask is, could I put the shed up there? The purpose of the shed is to store a snow blower, lawnmower,
Yeah, you gotta get
Tools.
it down.
all the stuff that you need a shed
Yeah.
for. Putting it up top there
Yeah.
would mean I'd have to snow blow all the way around the house
To get
to
the
get
snow
down
blower.
to the driveway.
You'd have to
You
snow
need it
blow to
for
get
it.
the snow blower. Yeah.
Correct. So it just
Yeah.
logically doesn't make sense to
Yeah.
put it on the upper level.
Noted.
Well, and I'm not even necessarily sure it would fit between the,
Yeah, I would have to almost put it in the center of the, closer, to clear the 20 feet boundary line, I'd have to
Really, front
be
to-
almost
feet,
to the backyard, or almost to the gravel part of the backyard where there's a,
yeah.
like a gravel
Right,
patio
there's-
type area.
correct.
Yeah.
Correct.
Okay.
Do I remember, is there a garage on the side there?
No,
Underground garage, no.
no, I'm sorry, yes. On the,
Up below, yeah, you
correct,
got
on
another.
that side of the house, there is a garage door.
Okay.
That garage door
Oh, yeah.
is where I'm currently storing the snow blower, lawnmower,
Okay.
which is part of the basement. I do not foresee using that at all as a garage.
Okay.
And at some point, I'm probably going to get rid of the garage door. I have a workroom right to the side of it for my tools, and I got spoiled by having a two-car garage with a workroom and a loft.
Yeah.
So all my tools and stuff, I got rid of a lot, but I still have a fair amount that just for construction and toys.
Yeah.
Boys' toys.
Boys'
You
toys,
don't have to
right.
explain to me.
But ultimately, that, where I'm parking the snow blower right now is right next to her freezer.
Yeah, not ideal,
If they have to move them out of the way to get to them.
not good.
So I'd really like to, that's the need for the storage shed. We currently have renting a 10x10 storage locker for the other tools that we moved, that I'm waiting to build the shed till I can move them in. And that's why I'm going for 10x12, to have that little
Well-
extra room for the snow blowers,
Good.
snow blower and lawnmower.
I had to do an 18-foot so I could get my kayak in.
Yeah, yeah, that's the other,
Yeah,
my
Okay.
kayak is in the basement as well.
right,
Um,
and the carport.
Okay, so that's the shed. The carport, the driveway, when you enter in, it has, you can go straight in, which, coming in off of Burn Road, when you go straight in, that would lead you to the, where the shed's going to be located.
Yeah,
If you go to the right, you kind of go up, and then there's a smaller parking lot up top.
yeah,
That's where Patty parks, that way she can go in the front door,
yeah.
without doing stairs. We're looking to do a carport instead of a garage, because there's really not enough room to do a garage up there. And, I'm willing to, keep my car down below, for me, it's not an issue. But for Patty, we'd like to have car shed, something she can park her car under for wintertime mainly, so that she can keep it out of the elements, not have to brush the snow off the top. And it gives her the ability to park her car in a covered environment for
Bringing in groceries and stuff like
Yeah.
that. to park up
Like-
top.
parking up top.
Like, yeah.
I positioned it when I was looking at where to position it, I have positioned it to the farthest away from the house. When you come up the drive, it's a natural to just come straight into the carport. That, yes,
Your driveway is located on Burn Road.
correct.
Okay.
Right. It actually, so we actually have.
So you
kinda
have
like
no
a wall.
driveway on Edelweiss.
No,
No, it's kinda
This
funny
is-
that we got that address, cause it was supposed to be, I guess, when they were gonna build it,
Ah,
but they didn't do it.
yeah,
okay,
yeah, this really helps that, this map, yeah.
yeah. I'm just making sure there was no other entrance on
Right.
Edelweiss. Okay, so you come in, there's sort of a driveway right there that
Yeah, you hook,
Curves
as you're
around.
going
You
up,
go, you
right
go up.
underneath.
up,
Right.
yeah,
You-
gotcha.
Yeah, there's two. One entrance,
Yep.
but you go
Yeah.
straight to the lower parking lot or
Yeah, you
go
can
up
see
the
it.
hill to the upper
Yeah,
parking lot.
it's clear on this actually, on
Yep.
the photograph actually. Okay,
And that carport is 13 feet from the edge of
Correct.
the road,
From our boundary line.
from your boundary line.
There's another
47.
additional 10 feet to the edge of the road.
yeah, it's
And
And
47
then
to the
it's
centre of the
47 to
road.
the center.
It's all
Correct.
wooded right there too.
Yeah, yeah,
Mhm.
you can see that on the
That's why you
photographs.
have a natural boundary right there,
Yeah,
Correct.
yeah.
yeah, right between, yeah, you've got, it's all completely shielded, yeah.
And then in the, in my write-up, this winter I was watching the plow to make sure that a carport wouldn't be in anybody's way or destroyed by the snow being pushed over. There's plenty of room, even when they came by and actually pushed the snow to, you know, halfway through the winter,
Yeah.
they pushed the snow back even further. There was no problem with the snow coming into
Yeah.
where the carport would be.
Yeah.
There was also, it's in no way in the snowplow's way. There's trees, a buffer of trees between where the carport would be and the road. So I don't see it as any kind of a problem for the DPW snowplows, or for us.
Away from there.
If I move the carport closer to the house, the problem I run into there is I'm encroaching in on, you can see the septic vent.
Yeah, yeah, yeah.
And so to pull it closer to the house, I would have to move that septic
Ugh.
vent. And the other thing is, it then puts it really, right now, we could park 2 cars up top. With the carport in the position that I am planning, I would still be able to park 2 cars, one in the carport, one next to it. My brother is a handicap that comes to visit quite often, and he parks up top as well. If I move the carport over, because I do have 20 feet from the edge of the house, I'm allowed 8 feet, I believe it is, or 5 feet, sorry, 5 feet from a structure, for the setback. Right now I have 20, but if I move it over, I'm like making the rest of that parking area useless.
That's
So-
the septic's right there too.
Yeah.
And that's the real killer, is that I can't really move
No,
it straight over because of the septic. I would have to move it down the hill and over, which just doesn't work.
yeah.
Yeah, got all this, Drew?
Yep, I'm paying attention.
Okay.
It's quiet.
No, I just, well, because you know, I don't know if, you know, like, wanna make sure
Yeah,
you
I've got the pictures and I can, you know,
follow along,
And you had it outlined nicely. when I
Yes.
went-
Yeah.
when I went up there.
yeah.
Yeah, I have it, the location's pinned and I
Yep.
red marked it with paint. I just did it again today in case you came up again today.
No, I thought everything was in a great spot.
So you've been to site,
Huh?
you went to site.
Yeah, it's very
Bless you.
comfortable.
And then I included a picture of
Yeah,
the style of shed, just a wood, single door, single window, nothing too fancy. And then the carport, so that you
simple
get
carport, yeah.
a feel for what I wanted to do there. Just a straight metal with a roof and possibly a side on the roadside.
Good idea.
You've got an application for a variance for a certificate, there's a plot plan waiver in here as well.
I'm sorry, the what?
There's a plot plan waiver
Right.
in here as well, yeah.
There is, but I think we're accepting,
But I think what we have is good,
is,
yeah.
right. We accepted this as his plot
Yeah,
plan.
I was, that's where I was going next, because it seems like that is. Yep.
Okay, does anybody have any questions?
Yeah.
Go ahead, Doug.
I'm thinking back to the discussions we had with Mr. Moscone putting in a carport. And I'm remembering that if it was a non-permanent structure, it did not need a permit. But because the way he was building his carport, then he added a roof on it. They made him come in for a permit. So I'm wondering if in this case, he doesn't need a permit for his carport.
Is this affixed to the ground?
Well,
So, yes, to keep it from blowing
Yeah,
off,
staked.
from blowing over, but the, so I would have to say yes, it is not cemented in, it's
Just
just
screwed in, so
Right.
it could be unscrewed and moved.
It could
It's a
be.
temporary structure,
See, that's
technically.
why-
Correct, it would be
Right.
considered temporary from that point of view.
Yeah.
It's not truly,
No.
I'm
It's
not
not a
putting it on
permanent
pad.
structure.
I'm leaving the dirt ground, just
Right.
leveling it off with, you know, with a rake
Yeah,
and,
it's like putting a rhino up, except it's a little tougher.
yes, actually it might be easier.
Yeah, anything's,
Yeah, Henry's was different in the sense that he was really close to it.
He
yeah.
was very
He
close
was
to the
on
road.
the
He was,
line.
he was, yeah,
Yeah.
and he was affixed to some rock structure underneath
It was
it.
super
Something he
fixed,
did,
yeah.
Yeah, he had either had,
And it was
Anyway.
big, wood pegged,
Yeah.
you know,
Yeah.
big wooden
Beam.
structure.
Going over an enormous
timber
RV.
kind of,
Yeah.
it was pretty,
It started with just the roof and then it just sort of grew from
Yeah,
there.
Right.
didn't it? Anyway, yeah.
so do we believe then that, so you haven't actually done any of this, so you
No,
didn't get
I've
you didn't get a letter from Bob Boyd saying, don't do this? This is basically, you just knew that you were gonna be too close to,
No, I did apply to Bob,
oh, and
and,
he,
and he, right,
oh, building permit was denied, okay.
right.
Yeah.
Yeah.
We got it right here.
Don't have it, okay,
Yeah, we got it.
you may have.
No, it's not.
I went through, like I said, 3.5 hours of documents today.
And the carport being less than 20 feet from the edge of Edelweiss Drive,
It's because he thinks it's a permanent structure.
right. Drew, do you have thoughts on whether or not the carport's a permanent structure and whether or not a permit is actually required?
Yeah, that's an interesting question.
I can tell
Kate?
you, not that I wanna cut
The
in.
question would be,
Can we go back and pull what we actually said at Moscone? What the
Well,
criteria was that we,
yeah, you know, we read it out of the definition. There was a question, definition in their zoning ordinance.
We need a permit for
What
a
a fixed-
temporary structure.
And
I do too, I just know because I went through it with my own.
maybe
You
somebody
know where?
can pull up the zoning
I went
ordinance.
through it with my
We're all
own.
talking
alright, I have the
Hold on.
zoning stuff with us.
We
Yeah.
were gonna put up a temporary structure and Bob said we need to have a permit.
You know what the,
Bob said you needed a permit.
Yes.
Do we know that Bob is correct?
okay,
Yep, he told me I needed to have a permit to be able to do it.
32.
And that the zoning ordinance, they changed that and that is
Hampshire.
what he told me,
Zoning Board of
so
Adjustment,
I didn't do one.
where's
that's right, okay.
the master plan?
He's the boss.
don't need to do anything.
No, not really.
Well, it seems to me that when you start talking about carports, there's something in the back of my mind that years ago when they came up with all those tent carports, that they made a change in order to require a permit for
Yeah.
those, so that they were placed in places that were legal, so I guess I would probably lean just for the sake of,
Doesn't-
I mean, it's not gonna hurt us to act on
No.
providing a variance
Right.
No,
to have on the
not at
assumption.
all.
Oh, based on,
We grant the variance. If we don't grant the variance, that's another issue, but, I think that the reality is that, we're probably safer just saying it's a structure and, you know,
That's fine.
what I can clarify with Bob for the future, you
That's
know.
fine.
I mean, that allows us to act on it and be done with it.
Yeah.
Yeah, I've got no problem with that.
Yeah, let's not look for trouble where there isn't any.
Well, only in the sense that I wanna make sure that we're being consistent, that if we made a statement that carports don't require, that are considered temporary structures don't require, you know, if we did that in a prior case, I wanna make sure
Understood,
that
yeah.
we're doing it
Understood.
again in this case.
But that was also really like on the edge of the property. I mean, it was literally fall off the road into it. You know.
Purposely so we could back the truck into it
I
and
know.
get that in there,
I know.
right? I don't blame them, but, you know,
But,
still
you know,
not right, but, okay, so we just wanna, we'll just, regardless of whether or not a building permit is required or a permit is required, we're gonna act as if it is, and we're
A
gonna,
structure, yeah.
yeah, we're gonna rule on the structure.
Yeah.
Okay, do we have any other questions or any other issues or anything we wanna bring up or ask Mr. Burnell about before I close the public hearing?
I'm good.
Drew?
Nope.
No? Doug?
Nope, I'm fine.
Okay, then I move that we close the public hearing. We don't need to vote, I just close it, right?
Yep.
Just like, whatever. It's 9 o'clock, do whatever.
Usually there's a motion to do it, but it's been going this way, so I'm just gonna go with it.
I'm gonna just close the public hearing.
Any findings of fact.
Yeah.
Alright,
Findings of fact.
findings of fact, 1. Applicant proposes to erect I'm gonna handle the shed first.
I was gonna say, yeah, do one first, so I move to the other.
To place the shed,
A 10 by 12, to place a 10 by 12
Yes.
Yeah, because once again, it technically could be picked up and moved at any time.
shed
Adjacent.
Adjacent to his home.
And within X amount of feet of the boundary.
yeah. Is that gonna be put on a slab or?
No, I'm gonna put
Just,
it on cement, not blocks, but the.
Piers.
The piers.
Sonotubes.
Not sonotubes, but the elephant feet and then the 4x4 posts.
Oh,
I
yeah.
wanna keep it up off the ground.
Yeah, so
and
the
then-
critters that do go under it can get out.
Yes, actually, I'm gonna block the critters from getting under it.
Yeah, good luck with that one.
We had that,
Groundhog, so
exactly.
I know.
We actually have 2 groundhogs. One's a beautiful black, all black groundhog.
Yeah.
I've never seen all black.
Wow.
The other one's brown.
What?
But anyhow,
Okay,
the,
Porcupines I'm not
Let's
in
get
love
you
with this
done.
year, yeah.
Applicant proposes to place a 10 by 12 shed adjacent to his home.
and I wanna and only 63 feet from Burned Drive center line. Before that, actually, that'll be 2. One will be,
This is 2,
this is 2.
okay.
One will be,
Shed.
no, the property at 8 Edelweiss
Burn.
Road is now
Yeah.
1 Burn
It's now
Road.
known
Yeah.
as.
It's actually dry.
known
Or
as-
drive.
Now known as One Burn Drive.
Is now
Yeah,
known
that
as,
sounds better. Drive, right? It's drive? Yeah.
Dry,
yes,
yeah.
yeah.
Got it.
cause somebody somewhere,
Yeah.
25 years from now will
How
go,
did you do
they
that?
never got a variance. Yes, they did, they changed the address.
Yep, so that's 1.
That's 1. So 2 is applicant proposes to place a 10 by 12 shed adjacent to his home and only 63 feet from Burn Drive center line. 3, applicant proposes to place a 12 by 20 carport parallel to Edelweiss Drive, and what is it, 47 feet from the center line? Oh, he has to be,
No,
wait, it's
13
the
feet from the boundary.
13 feet from the boundary,
Where 20 is,
where 20 is required.
And
and probably on the previous
and
one, you should
13
have said,
I will. 13 feet from the boundary line where 20 feet is required. Let's go back to 2,
63
3
feet.
feet from Burn Drive center line where 65
Yep.
feet
Yeah.
is required.
center line where 65 feet is.
Okay?
Yep.
We good so far?
Yeah.
4.
Carport.
Say again?
Carport? Or are we still on shed?
No, that was the carport.
That was the carport.
2 is the shed, 3 is the carport.
Right,
A 12 by 20 carport.
got it.
Setbacks based on the front and the side.
Okay,
This is burned, so this is the
what other findings of fact do we have?
That he's studied other locations and, you know, like we said with the last one, that they've looked at alternative
Yeah,
The
due to
location.
the topography and
topography basically, and current and existing structure
existing structures,
and hardscaping, because there's
yeah.
rocks and, you know.
Due to the photography and
Due
existing
to
structures.
topography,
Existing structures.
comma, existing structures, and hardscaping.
Yeah,
Oh, let's put, after existing structures, utilities
yeah,
and hardscaping, feasible, no, other feasible,
Other feasible.
there are no other feasible locations, there are not.
I was just gonna
there
say
are no other.
locations do not exist.
Yeah.
And the locations fit where these are going.
Are not favourable.
Do not exist.
Well, they exist, but
They-
they're just
but
not,
they're not-
they don't function.
Can you guys do me a favor, just so we can,
Yeah, sorry.
it's okay, it
Yeah,
just, I start to
they-
hear
there
and I
are-
can't.
Yeah, there are other locations and they do exist, but they don't function.
Okay,
No.
so due to topography, existing structures, utilities and hardscaping, other feasible locations,
Other
They're not
locations
applicable.
are not feasible, are not, you know what I mean, in other words. Cause there are other locations, they just don't
right,
work.
I understand,
you know,
yeah,
so.
I'm trying to reword this. No, okay, after hardscaping,
Yep.
put no other feasible locations.
Exist. Work, whatever, well, feasible is work,
Are appropriate.
Good.
You have any comments on that, Drew? Doug?
Oh,
No, that sounds good.
Okay, do we need any other findings of fact?
no, I mean, that runs parallel with what we've been talking about before.
Okay.
By the way, just in passing, I did look up the definition of structure in the zoning ordinance, and basic definition is any structure that's built for any kind of use or occupancy, whether it's permanently fixed or not, whether it's
Okay,
lawn
That's-
fabric,
So
frame,
that
or
answers
whatever.
Yep, I went through it.
thank you.
I think that's what it was
Right,
was the definition of structure.
right, yeah, so it's a structure, and if it meets the definition of, and of course, it's $8,500, is the minimum. If it's less than 8,500, it doesn't need a building permit.
The
Based
shed
on the,
probably is less
Total
than
Is your
construction cost of materials, if the contractor did it.
So the shed is roughly 2,500 and the carport is roughly 1,000,
Okay.
but
Yeah, that's interesting, so,
So technically, you wouldn't have had to apply for permits for either one of them, you could just direct them.
honestly, I don't think that's true, because when I talked to Bob, it was explained to me that any structure, Now, that gets into a gray area, if I put up a tent in my backyard, do I need a permit?
Like a rhino shed?
As long as
Rhino
you-
sheds, you do
as-
need one for.
As long as you have
Tried
it
to
for
do
less than a year,
Yeah,
you don't need a permit.
you need a,
So so like an
That's-
an awning, like a
Mhm.
screen tent,
That's,
Yeah,
that's, I kind of
Makes sense.
assumed,
Yeah, that's
I was
temporary.
taking that to the
I
limit,
just
but,
looked at it online,
you
New
know,
Hampshire
I-
regs.
I put a circus tent in my backyard that had 225 people underneath it for a wedding, and I didn't need a permit. So,
Okay.
I would think that,
Like
I only had it for the
rhino
weekend.
shelters, cause we were gonna do one
Yeah.
in Bob's and we need a building permit for it.
For a rhino?
Yep.
every,
I've been breaking the law for a while.
No,
No, it's
Say
done.
it.
that's on record.
It's gone.
Don't
on the-
say
It's
it.
gone. I was before I was on the board, yeah.
If you can get away with it, more power to you.
No, it was a long
I
time ago,
can't,
trust
I
me,
live
it
right
was,
next
it's
door,
gone.
so I
Grandfather.
can't, I'm an eyesore.
all right, let's
10
let's
years
keep
ago.
going, it's 10 after 9.
I
Yeah.
think
Yeah.
that
We
eight
got one
thousand
more to
dollars,
go.
there is some other, I remember reading that somewhere.
I do know the $1,000, if it's in the things, if it's under $1,000, you don't
I
need it.
think the $8,000 only refers to modifications to a current structure.
Mm.
It doesn't talk about new structures.
Yeah,
That
that's
sounds
true,
right.
yeah,
That
that's
sounds
true.
That's good enough
Okay.
for future.
Yeah,
Okay, so let's go through the variance
Yep.
pieces. The literal enforcement of the provisions would result in an unnecessary hardship, so what we said about the topography, existing structures, utilities, and the hardscaping, he would end up having to put this someplace that
would
doesn't-
create a
would
problem, yeah.
create a problem, yes, would create a larger problem
Yeah,
than 2 feet of
Yeah.
setback. No fair and substantial relationship exists between the general public purposes of the ordinance provision and the specific application of that provision to the property.
no.
The setback requirements ensure public safety, but this isn't gonna interfere with that.
No,
And it doesn't place a burden on any other local abutters or the Department of Public Works with regard to the corner and the street.
right,
That was my main concern, was it gonna be any plowing issues, and
mm,
it won't.
You don't wanna plow it over.
I don't wanna plow it over, nor do I,
Or bury
I
it.
didn't
One
want
of
them
those
to.
trees all there,
to
I
have
have
to
to get through the
avoid it.
trees.
The proposed use is a reasonable one.
Yeah.
Yes, it's reasonable to have a shed and or a
absolutely,
carport.
yeah.
Are you using these in the,
Yeah, use the ones in the application.
you did a good job too.
Right.
Thank you.
You should train all the other people in town how to do
Both of you.
these.
You wanna be on the board?
Right?
I
You
know.
wanna be on the board?
You wanna be on the board?
After we're done doing all our building,
Yeah,
oh, that won't stop.
yeah, trust me, it doesn't.
Okay.
actually, I was in Boy Scout committee for 27 years, so I've
Oh, yeah,
sort of done my committee stuff.
yeah.
You don't wanna
So
know.
let's propose a motion to approve,
To grant.
Grant,
to grant, I know, I'm sorry, I always say approve.
that's all right.
We know
To
what you mean.
grant
We do.
Variance request.
variance request. Let's handle the shed first. For a 10 by 12 foot shed.
That, what are the addresses?
Oh, God. That's,
can we do them both?
we're gonna, it'll end up being both, but I wanna make
Yeah,
sure that we
single
capture the
ones.
pieces for the,
Okay.
yeah. A 10 by 12 foot shed. It's- I'm brain dead, what am I
To
doing?
be,
10 by 12 storage shed,
to be,
63 feet from,
Center line.
63 feet.
from center line of Burn Road, Burn Drive,
where 65 feet is needed,
where 65 feet
Is required.
is required.
is required.
Could, before you formulate that, is there
Any
room?
wiggle room?
any wiggle room, 6 inches?
Oh,
Because
there
I
is.
know Bob said that it had to be from the furthest most point of the shed, like the shingles. So
The
I'm trying
overhang,
to,
yeah,
trying to
Overhang, yeah.
take that into account, but,
yeah.
you know.
Give 'em a
Applications. We changing-
Tell Bob about your Boy Scout thing, he's a big Boy
Yeah,
Scout.
we've talked, we actually
Yeah.
know the same people, so it was, I enjoyed talking to Bob.
Are we changing the application
Well, that's, cause the
It says
application
63.
says,
feet,
We
right?
have to just do it per the application.
the application says 3 feet?
63 feet.
63
Shed equals
feet,
63
right.
feet, so
I don't know that,
Where we're
if we
2 feet.
change the application, so,
It's fine,
Yeah.
Well,
I'm
63
fine with
feet.
what you decided. If
okay.
So
63,
He'll
63,
determine which bit of the building is gonna be there.
He's not gonna come back over and measure it afterwards anyway.
For 2 inches.
I'll do my best to keep the,
I do have a story like
The
that.
bit that's stuck
So-
out the
so-
most.
To grant,
Scott's honor.
grant a variance request for a 10 by 12 foot shed, 63 feet from the center line of Burn Drive where 65 feet is required.
Yes,
correct.
And to grant
for the erection.
a variance request
Yeah.
for a
For the
10,
erection.
what is it?
Carport.
Yeah,
Erection of a metal frame carport.
12 by 20 foot
Carport.
carport. 13 feet from side, no, 13
side.
feet from Edelweiss.
Center line?
Side boundary
From
is
side
the
boundary.
way it's set.
Edelweiss Drive,
I always
Okay,
drive.
Side boundary.
side boundary.
I'd always
Where-
drive side
where
boundaries.
20 feet is
Only-
required.
I'm sorry, Kate,
I'd always drive side boundaries, is that what you're saying?
yeah, I have
It is.
a 12 by 20 foot carport, 13 feet from Edelweiss Drive side boundary,
Okay, gotcha.
where
20.
20 feet is required.
Just a question, is it, but it's further than the center of the road, or is that also an issue?
So it was my understanding that because,
Only the front drive.
Correct. that it's where your driveway comes out, I have to do the 65 feet. Otherwise, I go to just the boundary.
A side
lines,
boundary
Side boundary.
requirement.
Which is,
Is that where the
Less.
blacktop stops, basically?
I'm sorry?
Is that where the blacktop stops?
Is what with blacktop?
No.
The side boundary of a road.
Hang on.
No, 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 it's the side boundary of his property.
Oh, of your
yeah,
property line.
there's another gap between my
Yeah, yeah,
boundary
there
and
usually
the
is.
road.
Right, yeah.
Okay, so do you have this whole,
Perceived line, not this.
Kate, huh, what? Do you have this?
I'm sorry.
I know,
I'm sorry.
it's 9:15, come on, we got a lot to do
I
still.
know, I'm sorry.
It's all right.
Request for, we're at a 12 by 20 carport, 13 feet from Edelweiss Drive, side boundary line where 20 feet is required.
Yes, period.
So-
Yeah,
That's
that's
it.
what I have.
Okay,
I'm
Done.
good. I'm
Yep.
sorry.
so that's the motion, it combines the both of them.
Mhm.
We're not doing them as separate motions,
That's fine, I'd rather do that.
unless we were gonna approve one and disapprove the other.
Or add conditions or anything, we don't have any of
Right,
that.
we don't have any of that. Okay,
Second.
somebody wanna make the motion, this motion?
You made it.
Okay, Sharon makes it,
I'll second it.
okay, second
Roll call vote.
is Doug. Yep, roll call vote. Drew,
Aye.
Jennifer,
Aye.
Doug,
Aye,
Sharon, and George. Aye.
done.
5-0.
Major appeal stuff.
Okay,
Thank you.
if one wishes to appeal, one must act within 30 days of the date of this notice. Date 1 being the day after the date of decision. The necessary first step before any appeal may be taken to a higher court is to apply to the Board of Adjustment for a rehearing. The motion for rehearing must set forth all the grounds on which you will base your appeal. See New Hampshire Statutes RSA Chapter 677 for details. Case number 63, oh, 63, listen to me, 23.
2503.
2503 is closed.
Yes.
Thank you.
You're
You're
welcome.
welcome. Thank you. Thank you
Two
for.
of you is done.
Now, if
Pleasure.
it was an STR,
Sharon?
you'd be in trouble.
Yeah.
As you've seen,
I think the house that we bought was an STR,
Yeah.
and I think that they,
That's why they
I
sold
think
it.
they sold it
Yeah,
because
It
of
may
that.
be. Oh, I
a
did,
lot of STRs
I
out
didn't put
there.
in there that you're only on 0.46 acres, so, but I don't know that,
Too late.
I
I'm
don't
sure we're
think that
fine
matters.
without it, yeah.
It's
I'm
in-
sorry,
it's in my
Ethan
paperwork.
has a question?
He
The
does.
language we used was off of perceived line that we put on here, not this line. So I don't know if you wanna edit that, because
It's the
the
corner.
line actually exists out here, and we said 7 feet from this line, well, it's this perceived line because we're ignoring this space. So I just, like when Bob picks up the permit and goes 6 feet from the line, he's gonna follow this line, not the perceived line that we built ignoring this.
So then you're saying the whole thing is within the.
Currently,
we were
currently,
ignoring
if you
this
use that blue, the dark blue line, the entire shed is within that
Okay, that's.
that bubble,
Garage.
With the- all of
or
them.
garage.
You're on the shed stuff.
The entire garage is
You're on-
within that bubble.
I know.
However, that bubble is based on that small piece of area
Just
in
that
the
corner.
purple that doesn't actually. Nobody knows how it got designated as a
Yeah, we
piece
have
of.
evidence base shows that it does,
It's not
it
a
drains
wetland.
fine, so
But,
I don't
We can't
I don't
go
wanna
back.
have to come back with, once Bob goes, well, which line are you using and what's 6 feet, because, or,
right.
because we perceive this line ignoring this patch.
Who actually made the dark blue line being,
That is drawn by the, by HEB. That is a surveyed line, that is
Okay.
exactly 30 feet.
so that's the official line.
That's the official line,
Uh,
ignoring the official line because of, ignoring this space because it drains just fine. We perceived this line.
Do we have to go back and reopen this case and just and figure that out?
I believe
Sorry.
so.
That's okay. No. We'd rather figure it out now than have it come
Tonight?
back.
Yeah,
Tonight?
Oi,
Yeah,
Yeah, tonight.
So it has to be more than 7 feet.
well, that measurement was off a perceived line when
we're
we ignore
starting
this
over
space.
again. Cause the whole thing's in that one. That's
So
a
Drew,
whole-
any advice? Or so we'll reopen the case and we'll discuss that. But at some point in the findings of
Keep
fact,
while
I
we're
think we
getting's
need
good.
we need to address the fact that we, I don't want to say ignored, but we perhaps discounted that.
Yeah, do we
That-
just put a line in there that just says we're discounting the small area that evidence shows is not poorly drained? I just don't want you all to run through this again in the next meeting because Bob's like, well, which line are you using?
Right. Do you know what we're talking about, Drew?
No, I'm kind of having a hard time following that.
Okay, so he's gonna.
This blue line, right?
Watch his,
So
look at your
Come
camera,
look at your camera.
look up.
Look at your computer.
Okay, hold
Can
on
I
a
ask
second.
you a question, or do I wait to get something from you before?
Explain it, sir.
Okay, yep.
So you agree the building can go here. We use some evidence to just say that this is not poorly drained. It drains just fine. I can stand in the middle of it and whatever. So the line would exist here, and so in the verbiage, we use 7 feet from this line, but that is a presumed line. This is what Bob's gonna look at.
So technically, if you look at that, from the line that has that bubble piece, the entire garage is inside that wetland bubble. But
Oh, I see. Yeah.
but because we discounted the fact that that small piece that's in the purple, I think it's purple, that small piece that looks like an arrow almost, that we discounted that was actually wetlands, we superimposed a new line that connects the edges of the bubble almost, sort of, not straight across, but in a little bit of a,
It falls
dip.
30 feet from the poorly drained.
yeah, it's
The
30
lineage
feet
on
from the
there.
poorly drained.
Yeah, right.
But HEB didn't do that. Mr. Lemieux did that.
Yeah, my hashed line is what I drew as a presumed line if you ignore.
If you
Yes,
ignore
Lord.
that. And it's that line that he's over by the 6 feet.
7. Right.
7
No, no,
feet.
it's
We
7.
granted him 7 feet.
Yeah.
He's over by 6.
Right.
Just that corner.
Just that corner. So in the findings of fact, I think we have to state something to that fact. That while the drawing shows a bubble area
curve.
physical evidence,
Okay, so wait, before we even do this, the question I have is, do we need to reopen this case in order to address that? Or can we just amend
The motion.
the findings of fact and the motion?
We need to reopen it, I mean,
Yeah, I think so too.
I mean, it's not a problem, I mean, the applicant is in the room and
Right,
Agreeable.
and there was nobody else here,
No, there was no one else speaking to it that's
Right.
left.
right. Alright, so, what number were you?
2502.
2502. Do I need to have a motion to reopen it?
No, you're
think so.
Chairman, you can just reopen it.
Alright, I'm reopening case 2502. And we need to address, and I think we need to discuss, are we within our right to discount that?
I don't think we are.
To discount that turquoise area?
So we're reopening the case to address
Location.
location?
We just grant the
I don't know
variance
which
so
one.
that, the garage can be,
Within the wetlands?
Yeah,
yeah, because because what we're doing is we're still granting, effectively, what the question is can we grant a variance so that the corner of the garage can be, I'm just gonna say, clarify this more precisely, but the point is, the garage can be approximately 24 feet, from the wetland, instead of what's the requirement.
30, I think.
30, yeah.
We had 30 in there. didn't we?
Yeah, because it's only showing.
if you
20.
put 116 feet from the property boundary, which is marked on there, then it pins the garage where
Yeah, you
the
can see.
location is approved on here, cause, Bob's just gonna say, well, it's hard to determine where you're locating it without some physical
Reference.
reference
Yeah.
point, and our reference point,
Is the road.
doesn't it technically exist on the map? So if we set it from
Yeah,
the,
That's
the
centre
property boundary,
across.
116 feet to the corner, that,
To the
pins
south,
the
to the
location.
southwest corner.
that's the north, it's
Oh,
the center of the north, so it's
Oh, it's
the,
north the other way around. It was 116 feet, it's showing to the southwest corner at the moment, where the 32 begins. That's southwest. There's north
this
up
is
there.
measurement here.
Oh, I was reading that 106. Oh, you've got
That's
two
the house.
116s.
The
Yeah.
house is 116,
Yeah.
but the northwest corner, which is the one that's into the
Gotcha.
wetlands area,
Yeah.
is 116 feet. And now that gives Bob and anybody else who's gonna question the variance, the point to measure from, not
Yes,
this,
exact. Yeah, I
exists.
understand.
this perceived line that we drew on the map.
I stopped using the word perceived.
Okay, so,
I'm a nurse, and so I use a lot of
Sure.
perceived for
We
risk.
I live with a
I'm
PA,
sorry,
so-
can you guys stop? I can't hear
We
Kate.
can refer to what's on, like, to the plan. Refer to what's actually on the plan.
I'm sorry, what are you asking me? All I heard is refer to what's on the plan.
What's on the plan, what he's trying to say, why don't we refer to that plan?
I'm not saying we aren't.
No, but I'm just saying that may help, referring
We have to
the
open the
plan.
case
Oh,
and we
yeah,
have to
no.
fix the findings of
Right,
fact
Right,
in
First.
order to.
but put in your findings of fact, referring to that
Let's
plan
open
as
it.
well. You know what I'm saying?
Let's open the case.
Yeah,
She
well,
did.
we opened it,
We
yeah.
have?
already.
Okay.
To address something. We haven't figured out what we're addressing.
Well, it seems to me that, the issue here is that we have created a line, that's based on an assessment of that particular area not being a wetland, but the reality is if HEB put the blue line there, then we're granting a variance so that the garage can be, 24 feet from the edge of the wetland. Now, if I understand it correctly, why is that blue bubble there? Because that little triangular area,
Yeah, so the turquoise space is on the map is poorly drained. Most of the photos added for evidence is showing that it drains just fine, it never pools with water. But when you take the computer and you just say, give me 30 feet from all these points, that's what the solid blue line is, which is me just drawing over the 30-foot boundary that is drawn on the site map by HEB. So it just takes the average amount, and that's,
Yeah.
Yeah, see, but like our finding of fact number 2 says, the applicant seeks to erect a 24 by 32 foot garage
Approximately 24 feet.
approximately 24 feet from poorly drained soil. That's
Well,
not necessarily true
No,
now.
no,
If
no.
we're looking at this,
No,
Yeah.
yeah,
you
where
seek
7
to
is.
erect a garage wholly within this bubble,
24 feet, yeah.
a wetland bubble,
sure.
and 116 feet from.
But interesting enough, Ethan created that line, that bubble line. That's
Well,
not part,
it-
that's
I
not part of the survey map.
Yes, it
Yes.
is.
It is.
That
You
is
just-
a survey
You just
map.
Oh, it's overdrawn?
I just
Okay.
drew it to highlight it so
Got
you
it,
can
got
see
it.
the space I'm working with. My hashed line is, if you ignore
The turquoise
the
piece.
turquoise space, that hash line is the 30-foot mark
Right, where the
from
7
the
is.
truly poorly drained soil. The other thing is just a low spot in the,
So because of that turquoise
Yeah.
piece, they
Right.
drew a 30-foot boundary
Got it,
around it, which makes
understood.
that bubble.
Understood, it's
could
a
we-
radius, yeah.
Could we say within a perceived, area of poorly drained soil?
It's not perceived, they,
It's
Said
back.
it is.
it's on the
Well, but
thing.
I understand that, but photos show that it is not poorly drained. That's all I'm getting at.
And I understand that, but, you know, again, looking at it from a different perspective, where did they get that? I mean, when they went out there, it had to have had,
A
it's
reason.
low, but that's
Yeah.
really it.
They
And
probably did that with,
when you talk to Bob, it's like, these things are so arbitrary. When he was a forester, it'd be like, one would tell him that the boundary line's over here
Yeah.
because of this water, and then it's 100 feet over here. So
right,
the soil scientist in 2004 just was like, well,
That
that's
looks wet.
low. It wasn't, I don't know what they used for evidence, but
probably altitude gradients.
Mm.
You know,
Yeah.
They're looking at the.
Mm.
whatever,
alright, so I guess what we wanna do is recognizing that now this is going to be completely within a specified
Surveyed.
surveyed wet area, whether it's appropriate or
Yeah.
not. We need to address the findings of fact, to address that piece of it, that it's gonna be contained wholly within that. And 2, does that change our decision? And I mean, I don't, for me it doesn't, it's still, the fact remains, it's still the same pictures that he showed us, and we're okay with it being there. We just now have to show, for Bob's sake or anybody else's sake 15 years from now, that you put the garage in the right place, that
And
you
then we
didn't put
did
it
our
in the
due
wrong
diligence
place.
discussing it again.
Right,
And it isn't just 7 feet in the corner, we'd have to take
Correct.
that wording out, you know.
so now it fits wholly within
The surveyed
the surveyed,
area.
Buffer
indica-
area.
But
Surveyed buffer
evidence
area.
indicates that
Yeah,
small areas is not poorly drained, and that truly poorly drained soil is 24 feet or something like that. Or whatever you,
a lot of words.
a lot of words.
okay, so right now, we're gonna strike number 2 completely,
We're taking
Okay.
out number 2,
yeah?
and we gotta figure out, we're opening the case, we gotta say what we're addressing it for, so.
Yeah, why are we opening it? She
Yeah.
didn't finish that sentence.
We haven't yet, I just don't wanna
Oh.
lose track of that.
Sorry.
That's all right.
We're reopening the case in order to address,
New information.
Line adjustments or something to that
No,
effect, that's what
no,
you're
no
doing.
lines have been adjusted.
You're doing something,
New information.
to address,
well, it's not new, cause we had it when we were,
Yeah,
the same
it implies
information we were
it is
doing.
or
Right,
Yeah, but
elsewhere.
it's new-
Now we're basing it on a different set of,
Right.
Criteria.
criteria.
How about, to address the location of the proposed garage in relation to,
Poorly drained.
additional boundaries besides poorly drained soil?
Or clarification.
Additional
somewhere.
boundaries. Besides, what was it again?
Besides poorly drained soil,
Beside,
or in addition to poorly drained
In
soil?
addition, I like that,
Besides,
in addition. Thank you.
Does that make sense,
I just
Drew?
didn't wanna
You
get
agree with that,
lost.
George?
Yeah.
Yeah, sort of, I'm not sure where we ended up, in terms of the whole sentence.
We are reopening the case in order to address the location of the garage,
Proposed garage.
of the proposed
In relation
garage.
to additional boundaries, in addition to poorly drained soil. Did you hear me, Drew? I'm sorry.
That didn't make sense.
He can't hear you.
No, you did,
Oh.
yeah,
Doesn't make sense.
he's deep in thought.
Does that make sense?
Yeah, it sounded like there were too many additionals in
Yeah.
that sentence,
So-
but yeah.
Relative.
Concept is right.
Reread it.
The syntax was okay.
To address the location of the property garage in relation to additional boundaries.
No.
Oh, what?
No. In relation to boundaries, or property boundaries.
To property boundaries in addition to poorly drained soil.
Right.
That sounds better.
Yeah,
I think
because
we're
we can
getting
use that
tired.
116 feet then, because that's relative to the boundary.
And then it ignores,
The
it
curvy.
gives you the location of the garage, not in location to a proposed line that we all agreed to use.
Right.
So the 116
It's real.
is real versus
Correct.
the 7 feet from a perceived line that we all agreed on here.
Correct. Which has no basis in any other
Correct.
other
Yeah.
Yeah.
thing.
Let's just
So
use
we-
the property
Okay,
boundary.
so
yeah.
now the motion,
This
All
is
right,
just a
that
motion
findings
to
of
open the
fact,
case, right?
remove number 2,
oh, I removed number 2,
and we
but
have
now.
to
oh,
add.
Okay, so number 2 now
Two is-
has to be.
I know.
What was it? The applicant
The applicant
seeks to erect.
24 by 32 garage approximately
Hold on,
160.
Hang on, you gotta
Hold
slow
on,
down, just gotta
hold
write
on.
this.
Seeks to erect a 24 by 32
Garage.
116
Mhm.
feet.
No, no,
Go ahead.
Hold on,
Within, well, I think we
Garage.
have to say that it's within
Yeah, that's fair.
within,
Yeah.
within the proposed, or within the,
Poorly drained soil section.
survey,
survey,
Surveyed.
there we go, surveyed,
Yeah.
poorly drained
Zone, area, whatever.
drained,
soil boundaries,
soil boundaries,
soil buffer boundary.
buffer
Because
boundaries,
it's a buffer from the poorly drained,
Yeah.
soilly drained
buffer
Buffer.
boundary.
soil buffer.
And is it
boundary.
116 feet?
and 160.
A distance of 116 feet or something?
Yeah, a distance 116 feet from the north
Town
Property
frontage
boundary.
line.
116 feet from the
Mm,
north,
Northwest
line.
property line.
there we go.
it'd be, well, it's not north.
No, it's
Oh.
north. It's
It's
north.
just the north.
I don't know where your
Because
arrow is.
Bob,
He's northwest.
straight up is, the property is oriented north-south. And so any line you pull is the shortest distance. So if you say the northern line, it's this entire northern line.
C1, yeah.
So if you wanna do it, it'd be 116
Your
from the
arrow's
north
right
line
here.
and 228 from the center of the road.
Right, so you
Well, now,
triangulate it.
Triangulate the location on the property.
And that's that's
Okay,
from
so
North
116 feet from the northern property line and 128 feet,
228.
228
From the center
from the
north
center line
of North Division Road.
of North Division Road.
And now you're triangulated,
You can't
on the
move it,
map.
yeah.
correct.
You got that? Does that make sense? Drew? Anybody got
He probably
questions?
hasn't even
Why do
heard
we
it.
say 116 where it says 136? Am I
What?
subtracting 20?
Which map are you looking at? This, if it's the one that came with the building permit, Bob corrected me in that I need to, the shortest distance,
Oh,
and that's
okay.
the shortest
That makes
distance.
sense.
That's corrected on the maps I submitted with the application.
So are
Yeah, you did.
corrected the findings of fact, is that what you did?
Yes, I'm
Yeah.
correcting
Yeah.
finding of fact number 2 to read, the applicant seeks to erect a 24 by 32 foot garage within the surveyed poorly drained soil buffer boundary at a distance of 116 feet from the northern boundary line and
Property
2
line.
But isn't it
Northern
only 36?
property line.
100,
Wrong map.
It's 116 feet from the northern property line and 228 feet from the center line of North Division Road.
That's the one I was reading.
Okay?
Yep, that's good. Now we
Okay.
can do the motion.
Now, yeah, the motion to grant a variance.
Well, should read just like the last.
Yeah, well, it should
Be
pretty
exactly
well,
the same.
I think you have to say
Request.
within this, I think you basically almost have to say statement of finding of fact 2.
For
Grant a variance
a.
To
request
erect.
Variance request to erect.
a 24 by 32 foot
the same.
garage.
Yeah.
Garage.
I think it's everything that's in the finding of fact 2. You
Yeah, I
repeat
see.
finding of fact 2,
FOF2.
right? With the surveyed poorly drained soil buffer boundary and then a distance of 116 feet from the northern property line and 228 feet from the center line of North Division Road.
All
So
right, who's
moved,
making the
who's
motion?
seconding?
Second,
Which one?
Pick one.
Doug,
I'm quicker.
Roll call.
roll call. Drew?
Yeah,
Aye.
Aye,
Aye.
Aye.
Aye. All right.
Fit to draw.
I still have to read.
I am done.
If one wishes to appeal, one must act within 30 days of the date of this notice, day 1 being the day after the date of decision. The necessary first step before any appeal may be taken to a higher court is to apply to the Board of Adjustment for a rehearing. The motion for rehearing must set forth all the grounds on which you will base your appeal. See New Hampshire Statutes RSA Chapter 677 for details. Thank you very much. Case number 2302, 2502
25,
is closed.
again.
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 Now, I'm gonna leave, I have to put the previous motion in there and just. I've never had this.
Well, you can leave it, and then in the minutes, we reopen the case and you go through it again,
Okay,
so they'll
That's how I'll
see.
do it. Yeah, I've
Yeah.
never had this,
Yeah.
it's the first time.
It's not like
First on the
if we
first.
changed our minds. it
I
might-
told on myself is what happened.
Well,
I'm glad
no,
you
and
did,
actually,
because
thank
Bob
you.
would have sent
Yeah.
you back here.
Right,
Yeah, I'm sure, because I've sat with Bob long enough to figure it out that, so.
Good.
Alright.
Still got,
Yeah, we do, that's why I'm like, let's
I
move.
have,
Thank you all.
Thank you.
thank you, thank
You're
you.
Stop by anytime when I
Pleasure.
start building.
Yeah,
Drew,
well, I'll be there.
I don't think we're gonna get to you.
well, let's get on with the other business we need to get to.
I need the, what did I do with the,
I can't speak to that.
There's a ton of minutes to go
Call to order.
No, I can't speak to that.
right, and
Oh,
as in you would have to step down
In
and,
case that we have to do the minute.
where are my,
What?
my agenda?
I've given you one already.
I know, I
Here.
don't know what I did with
Here.
it. Thank you.
2 hours, so I have to split it.
All right, we have to approve that we do not have the May 21st minutes, so those are not for approval. We have to approve the March and the April.
Yeah. March and April. It happened last time.
That's all right.
Okay, does anybody have any comments to it?
Hold on, let me get.
Yeah.
I had a few comments.
On the
And I
mark.
have a couple, yeah, on the March.
Yeah. Well, I sent these, in writing already to Kate, but on page 2, okay, now we're dealing with March, right?
Yeah.
We're dealing with March.
Right, okay. So on page 2, near the bottom, above the, paragraph that says Ellen McDonald, below the one that says Lou Krasinski,
Mm-hmm.
there's, in that sentence there underneath Chairman Gentile stated conditions, which is due process, not
Yep.
in due process.
I've got that.
What is he?
Which it, okay,
In the
it's,
last sentence of the page, preservation and the cell tower.
hold on,
Wait,
Drew.
wait, wait.
Hold
Hang
on.
on,
So
everyone.
the first change, Sharon, is under Lou Kaczynski. See where that name is?
Yeah,
Next paragraph, second line, conditions, which is, instead of and.
okay, so that's supposed to be which is.
Yes.
Last sentence of the page,
Then the next one is John Sexton, and Drew can take over from there if he wants.
Well, I have a correction before that.
Okay.
Yeah,
go ahead,
Okay.
if you're on the same page, go ahead.
Yeah.
are we on
under
page
the-
2?
Yeah, we're on page 2, under the Ellen McDonald piece,
Ellen McDonald, yes.
the last line,
Yes.
it says be submitted and approved. It should say
And.
with an approved estimate.
With.
Yep.
Okay.
And
And you had something.
I've got a little one under Mary Lou Dow. You've got a collage college campus.
Can they
It
call
should be EGE, not
Oh,
not
right.
AGE.
I read right past that. It's a collage. It's a lot of people.
It was a
Different
collage,
things.
yeah.
Okay.
Okay, in the last sentence of the page, asked if.
Yep, got that.
Asked if.
Which one?
Asked if at the bottom of that same page.
And asked if.
I have no idea.
It's
Page
right
2.
under John Sexton.
John Sexton, he stated the master plan prioritizes scenic preservation and the cell tower contradicts all of this. and stated-
Asked if.
What?
He said, that's what Drew put in there, asked if the tower really, I don't know, that's what he changed. I wrote stated as the tower really needed, but he's changing it to
The
asked.
tower is really needed. That's
And
what
stated,
stated is
Is the tower really needed?
if the tower is really needed.
Yeah, okay, got
If,
it.
stated if the tower,
If the tower, instead of is.
stated,
It's not really stated, he just asked.
Asked
Right.
if the tower.
Should say asked
It
if.
should say of this and asked if the tower.
alright, so what are we doing?
Next.
No, strike
All
the
of
word
this.
stated and make it asked.
Asked,
That's all.
that's what Drew had,
Asked if the tower
right,
is really needed.
Yeah.
That's what Drew had.
Right, I know, but I didn't understand that,
Oh.
because,
No,
why not? No, I'm teasing you,
Somebody would.
All right, you
it's
want
too
to
much,
Page
I
2
know.
still?
are we done on page 2?
Yep.
Yep, page 3?
Right at the top, where you have, at the end of the first paragraph, lot one,
Map 248, lot
That should
1.
be- You should have a period,
Yeah, is incorrect and should be map 248, lot 1, period. This would show where the tower would be.
No,
Huh.
that's the same.
or,
Alright, I'll just change it, I just.
or a
change
comma.
it. I'll just put period and name the sentence, move on.
yeah, keep going, please.
in
The only thing I had was down by Dale Grossman.
Yeah, Roseman, yep, I'm there.
It said, he stated that people needed a better visual, and it's like a better visual of what?
Yeah.
It's a better visual of the tower location, a better visual of
the
the,
tree next to it.
That's
the
all
bit-
he said. So I don't know,
alright,
If that's what he said.
if that's what he said, we'll leave
I'll
it.
walk out, yeah. Yes, sorry, I was doing,
The last sentence of the page.
Drew, can you speak louder or closer to your speaker?
Oh, okay, sorry, yeah, I had to take my earplugs out because the battery died. Last sentence of the page, okay? Inconsistent with the spirit of the ordinance and that the voters voted the ridgeline visibility limitation.
What?
And that there are other options. Does that make sense?
No, I don't, what,
the.
the voters voted on what?
The voters.
Voted.
The
The
ridge line.
ridgeline extension,
Didn't make sense to me the way I read it the first time.
and that
I
there are
changed it. No, it
other
doesn't make any
options.
sense either.
She stated there is no hardship here and this is inconsistent with the spirit of the ordinance and that the voters voted the ridge line,
extension.
Voted for the ridge line extension?
Yeah, and you voted for the ridgeline
Yeah,
visibility limitation.
Yeah, not extension, yeah.
Oh,
Visible.
I'm a terrible
I don't-
proofreader, because I see words that aren't there.
Ha,
okay,
that's real. voted the ridgeline visibility limitation.
I don't even know what that is.
No, I don't.
Like,
know.
what is when did we vote for a ridgeline visibility
We didn't vote
limitation?
in either, we
Well, they
just,
voted, that's the ordinance, the point is,
Right.
the voters approved the ordinance, that's a vague way to say it, the voters approved the ordinance with the visibility limitation. I don't know.
Okay.
Okay.
Next.
Page 4.
I got nothing on 4.
Anyone else?
Mm-mm.
5,
I got nothing on 5.
No.
6.
6,
I changed that, what I told you with the X, remember?
Yeah.
Police Chief,
Where,
Police
what?
Chief King submitted to this board a 70-page report detailing, and I said, we're just gonna say complaints, and took out the I will count them, cause the AI picked up Drew saying that, so we're taking that out, and we'll put it against short-term rentals, just leave it at that. So take out the X,
take out the X and the stuff in parentheses.
yes. You Drew with that, are you good with that, Drew?
Where are we?
On page 6,
Yep,
The paragraph
1, 2,
that starts
3,
with
4,
Police
5.
Chief King.
okay.
yeah, it had an X complaints, and then you said, I will count them. It picked up what you said.
how many complaints?
So we're just gonna leave it at
Just
police
complaints.
Right, a report detailing complaints against short-term rentals.
And move on from that.
Yeah,
Right.
fine.
If we move up a paragraph where it says the ZBA has the right to attach to conditions, it just should say has the right to attach
Where are we?
conditions. The paragraph above
Oh,
it,
that's quoted stuff that Drew had, so you wanna change that to what?
well, it just needs to
Yeah.
remove the second "to," the word "to" after attach.
The ZBA has the right to attach
Attach
conditions
conditions.
to the continued
The
use of
ZBA has the right to
pre-existing.
attach, yep, I took out 2,
Yeah.
okay,
Okay,
gotcha.
7,
I got nothing.
8,
I did on 7.
Oh, you did.
At the bottom paragraph, right in the middle, the board concluded that the appellants, is that correct?
Where are
Yeah,
we? The board?
appellants.
Appellants,
the
that,
people who appeal,
I
yeah.
guess they didn't, oh, good, so, that's all.
Going on 8,
I just had a question and I wasn't here. It said
What page?
Page 8,
Mhm.
under findings of fact, number 3, these documents established a history with the short-term rental usage and it circles 160 days per year, but it didn't establish the 160, it established 139 and the
We gave them.
15% added the 160.
Yeah. So it should say 139 there.
you okay, Drew, we're changing your findings of fact?
Yeah, that's fine.
Okay.
That makes sense.
So you wanna say uses of 139 days
That's it,
In a year.
in a year?
that's all.
Yeah,
That's all.
I
Okay,
just changed 160 to 139.
yep,
Yeah.
nope, got
And
it.
also continue that establishing a claim as a pre-existing non-conforming.
Oh, it says pre-exiting.
Oh. Gotcha. Okay,
9,
9, I saw nothing,
10,
saw nothing.
Down, if you go down on 9, after the paragraph that says Attorney Johnson,
laid out.
yep, at the last sentence in that starts with notably the Newells, comma,
Oh, yeah,
and then you have an extra line, an empty
Oh, yeah,
line.
that
That
shows.
line needs to come out.
there was a page break, I
What
think.
page you on?
Yep,
9.
Okay.
yeah, there's a big gap.
when you paginate it, sometimes it
Yeah.
does that.
Oh, yeah.
10,
10, I had nothing.
Nothing. 11, I had something.
11, I had, it's in
9.
bold, under 9 where it says that homes.
So that homes,
9,
where?
See, the words
got
that homes are in bold right in the middle of that.
Third,
Oh, I
third
think-
sentence of 9.
those were the ones that Drew sent me, but I.
Which page were we
Yep,
It's
alright,
on
so
Page
page
11.
you want me to
11.
unhold it?
No, I want you to
Oh,
remove
you-
them. It's
oh,
a
you put it in
duplicate.
there.
Yeah,
Twice.
yeah, yeah,
Yeah, you got that homes, that homes
Yeah.
twice.
yeah.
And then I had under 10 where it says points 7, 8, and 9 in the parentheses. I don't know why 7, 8, and 9 are grayed out.
Oh, yeah,
That's how I got them. He sent it to me that way, I don't know.
yeah, they're weird, aren't they? Yeah.
Yeah, if you looked at
They
I
are,
just
they're
wrote over
weird.
them, but they were grayed out.
Yeah.
Yeah.
Points. I think he means the findings of facts 7, 8, 9. I think that's what he was referring to.
Oh, that's fine.
Right, these findings, point 7, 8, and 9.
They don't need to be in parentheses.
No,
But
Well,
on my copy,
I
they're
didn't
fine,
want-
on hers, they're grayed out, that's all.
they're in like a light gray
they were in a
font.
red when he sent them to you. They were in red.
Oh, so red showed up as, okay.
Yeah.
12,
But I can make them regular color. I mean, I can.
Yeah, they
I
should
can
be.
fix that.
They should be
Yeah,
regular.
I'll just
I had
change it.
nothing in 12, nothing in 13.
12, there's a whole duplicate paragraph.
Did
The
I?
paragraph that starts with
Yeah.
Attorney Johnson.
I
it's
see
twice.
Yeah,
Yeah.
it's twice.
What's wrong with that? And you really get to,
just keep
Being
emphasizing it, yeah.
precise.
It's like when you do creative writing classes, they say write the same thing twice and
I
they
was
go
in bed
backwards,
when I
yeah.
did these things. Alright, that's cute.
Okay.
You are in bed, and I'm here when I'm doing these. How's that?
What about
So
13?
this was the one,
Anything on 13?
wait, yeah, so this was one of them. Yeah, so there, at the bottom of this, there's no statement that he, Chairman Gentile read aloud the provisions of the 30-day appeal,
Which one?
and he
What
closed the
page
case.
you-
Where are you?
I'm on page 12.
Where are we?
It's missing, you're not gonna see it there, it's supposed to be there.
Because it was a continuation. That motion was a continuation of a case, so it wouldn't be a 30-day because we didn't hear it. Are you talking
Oh,
about?
2320?
Yes, that
Okay,
was,
there was another one,
continued
then
that one.
2.
and then 2325,
Which is on the top of the next page.
2325.
2325.
Oh, I did it on, no, we'll get to
It's-
the last page, that's the one I fixed. Keep
Yeah,
going.
2317 it
Yep,
says.
I fixed that,
Okay.
yes.
What?
On so then I have nothing for that page. Page 13 I have nothing. And when you get to page 14, halfway down where it says Chairman Gentile read aloud the provisions, Chairman Gentile closed case 2317. It's not 17, it's 25. So it should say 2325.
Right.
No, that is case 2325.
It is, but it says
Yes.
2317.
Right, no, yes, it should be 25, correct.
Yeah.
Jesus.
I know, right?
Okay, so that's
Anything else anybody got
Nope,
on those?
nope, none of those.
Drew looks like he has.
Yeah, just a second, on the motion there, right at the top of page 14, it says after discussion, the board agreed to deny the appeal with conditions.
Which one?
Top of
That's right.
page 14.
Way at the top.
Starts at paragraph 5, paragraph 6, after discussion, the board agreed to deny the appeal with conditions as follows, but there are no conditions listed, so
Yeah,
we need to take out with conditions.
Oh,
Just deny the appeal, period, or
Yeah.
colon. Period,
denied the appeal?
period.
After discussion.
Well, except that you,
I don't think.
But
it's
then the
supposed to
motion
be-
comes
I don't
after
think that's
that.
supposed to even be in
I
there.
don't think it's supposed to be
No,
in there.
It's not, that whole line
take it
shouldn't even
out.
be in there.
Right.
Because the
It was probably
motion
from a cut and
follows that,
paste for
yeah.
something else, but, because then the motion follows, and then the roll call vote,
Yeah.
and the motion passed.
See, the clerk minutes that I use is very good, and it does a lot of it, but I also go through everything I have to make sure,
Yeah.
and sometimes you just
Okay.
get,
So I make a motion that we accept the March 19th minutes as amended.
Second,
Second?
Yep.
Roll call vote, all in favor? Drew?
Aye.
Jennifer?
aye,
Sharon, aye. Doug, aye.
aye.
I'm just gonna say it's amended with, corrections.
Yeah.
I'm not gonna go through all that, and,
No, just amended with corrections.
okay, now we're on to
April. Okay, so I have a serious issue, cause I'm confused, because during the May meeting, the cell tower people kept saying that they amended the height to 130 feet. But everything in here keeps saying 135, and the newspaper article said 135. What did they do? Did they amend it to 130 or 135?
I thought it was 135.
And I remember you saying that
Yeah, 'cause I said, 'cause
in May
it could
when I
end up
came
as
back.
155.
And
But that doesn't mean I'm right, I'm just saying I remember.
130,
I understand it as 130,
Maybe so.
because it was 150,
Mhm.
and they went down 20 feet, which is the standard height of
Yeah, yeah,
a
yeah.
set of cells.
Yeah,
So it would have gone to 130.
Yeah, it's 135.
135.
No, I'm sorry. It says 135 in several places, but it was, because we asked him to clarify that in the meeting, and he said it was 130.
Yes.
Because the whole point was that they had balloons at 170, 150, and
Yeah.
130. And the top of the tower was supposed to be 150.
Yeah.
And so he voluntarily dropped it to 130. Point was, then they could still extend it to 150 without any further.
right.
Right, but they couldn't extend it then to 170.
It was, I thought to myself, it's a bit disingenuous, because basically what they're saying is, they'll agree to drop it to 130, but earlier they have said they've never raised the tower 20 feet anyway, but of course this time they would have a reason.
Oh, they would have been right then.
But anyway, all that argument has to do with the symmetry of their operation, and I asked and clarified that, was it 135 or 130? It's 130.
Yeah,
Okay, so everywhere where it says 135, Kate, it needs to be replaced with 130.
Yeah.
and it does say.
On page
all over-
2, it's,
Yeah, it pops up.
it's the second line of the paragraph that says, in response to concerns from the public.
We're in April, right?
Yeah,
Let's see, page
Are we on May?
The minutes from
we're on
May should
April.
reflect that.
Okay.
We don't have Mays.
130. I don't even, 130, so it should be 135?
No,
No, it's
No.
supposed to be 130, not
But
135.
it is 130 on page 2.
No, it's not. I'm looking at page 2 and it says 135.
I'm looking at
Where?
page 2, I've got 130 right in front of me.
April 16th.
Yeah,
yeah,
page
To
2.
130 feet, 135 feet as a condition of
yes.
approval.
1, 2, 3, 4, 5,
This-
6, 8 paragraphs down.
1,
The
2,
paragraph
3,
that
4,
starts with,
5,
in
6,
response to
7.
concerns from the
Yeah.
public about tower height. The
100
next line underneath that,
Yeah, I'm sorry, it says
150 feet.
130, I was reading the 130 at the bottom
Oh, at the
of that
bottom, yeah, no,
paragraph.
no.
Yeah, it says
Got it.
135.
Yeah.
135, gosh,
Gotcha.
made me think I'm crazy.
It's alright, I know the feeling.
But there's, I got a correction on one.
Okay,
Okay.
Alright, where do we go? You get me confused now, so I'm doing everything to make it 130 feet, and now we're going back to something else.
yeah, we gotta start with page
Okay.
1 and go through.
Yeah, because I have things
Yeah.
from Drew too.
Okay,
Page 1, case 2408, right in the middle.
Mhm.
Variance request from John Springer, Esquire of Springer Law, authorized agent for authorized
Oh,
agent.
yeah, did
It's
twice.
double up.
What else on page 1?
That's all I got.
that's all you got? I don't have, you didn't have anything else.
Alright, so
Page
page 2, I'm changing the 135 to 130, and then in that same paragraph, it's 130 feet, the second part there, so I'm leaving that alone. Okay.
Yep.
Right, just to clarify, I just went back and looked at the notes for May, which we don't have, but we clarified that it was 130 feet.
Yeah,
Okay.
Okay, so-
We're not the only ones who got it wrong. The newspaper got it wrong.
Yeah, I know, but that's, yeah, it's fine.
Yeah.
So on page 3, Scape asked the tower to go an additional 20 feet above the 135 feet, or is that gonna be 130? Making a total-
130.
I did.
Making a total of 150 feet, then we're changing that.
Right,
Right. And the same
Not
in the next one.
155, even though that was said, so we're changing that, okay? Attorney Springer stated that there was a state law is in place and they could go to 155 feet.
Well,
So you
Right,
want
the
me to
state
make that-
law
It's 20 feet above the whatever you
So I'll make
agree.
it 150.
stated that there is a state law in place. You don't need the word is.
There is, st-
yeah, that's correct. Stay locked in place.
And I'll change what he said to 150. 130.
Okay.
Alright.
On the Ella McDonald paragraph, before on the last line where it says it would not be good,
Mhm.
put before that, put the word her. It should say told her
Oh.
it would not be good.
yeah.
Okay.
page 4.
Drew has some things here.
Nothing.
He
What
wants-
page does Drew have things?
Page 4.
Okay,
Drew has University of Alabama, take out and put
Where?
providing.
So, is it before Mary Lou Dow paragraph?
It's the first paragraph at the top. He further stated that we have studies and information from realtors as well as the document from the University of Alabama providing information and take out for radiation safety and coverage,
I don't know, what the hell paragraph you're
Oh,
talking
yeah.
about?
First one,
property.
at the very top.
so what are we taking out? Radiation?
On
or
page
what?
4?
Page 4.
Page 4 at the
First two
top.
Just read us what it
Your
should
page
say.
4 does not
sentence.
start where my page 4 starts. My page 4 starts with Rao asked what is the impact about radiation
There's
regarding
another
wildlife.
paragraph
Oh.
above that.
I've got he stated.
Not on mine.
He further stated.
Oh, because you got yours, you just asked me to send yours to you yesterday and it repaginated, so it changed the,
Change that.
Paragraph just before that.
yeah. That might
He
be
further
why.
stated-
Paragraph before that says Chairman Gentile stated that he has received reports.
No,
Looking for the
you're
paragraph
missing
that
an
says-
entire
I don't
paragraph.
have that.
You don't have the
I don't
paragraph at
have
all?
it at all. He further stated that we have
No.
studies and information. I don't have that paragraph.
Right.
That's odd, because the same minutes everybody has. I got
Anyway,
it.
let's correct it and get going here,
Right.
All right,
please.
Okay,
so
you
we
got-
took out the word and we put the word providing for Drew. And then we took out for radiation safety coverage, and he wanted me to take out, I don't know what the on means, on
So that it
property values.
Drew, what should it read?
He further stated that we have studies and information from realtors as well as the document from the University of Alabama
Providing,
providing information on property.
Yep.
Thank you.
that's what I got.
That
But
was
not
it.
anything on radiation safety coverage?
No,
No.
took it out.
Okay,
No, that's something else, that's an entirely different set of
What's the
reports.
FCC?
okay.
And actually, it should be University of Southern Alabama, so pop an S in there.
Yeah. 'Cause it is-
SO period. You wanna know where that is? For me, that's here. I have this. Chairman Gentile stated that the board must hold to FCC guidelines, which is 14% of permitted exposure level. He further stated that we have, it's not a separate paragraph, it's in this other paragraph.
Oh, it just continues from that one. Okay, anyway.
Oh, because it went on the next page for everybody else.
Right.
I don't know,
Okay, more,
Next page,
So
4.
Rao asked what, no, we're still on Drew's. Rao asked what is the impact of
of, yeah.
radiation? And that was it for Drew on that page. Anybody else on 4?
Yep, in the Mary Lou Dow
Yep.
section,
Which one?
right on
Page
page 4.
There's two Mary Lou Dow sections.
This one, the first one.
Top one.
The top one. It says Attorney Springer stated that there is a hole between the ridge lines and the gap will not get covered from the ridge line to the east and west.
Yep.
Dow stated the coverage is not enough. Attorney Springer stated it's duplicate. The whole next line after that, Attorney Springer stated
Yeah.
that there is a hole between, it's
Yeah,
a
and the gap will
duplicate.
not get covered from the ridge lines. Yeah,
Yep, Dow stated the coverage is not
I just
enough.
did it twice.
Yeah.
yeah, and to the, all the way to east and west.
All the way to the next sentence, Dow stated the
Yeah.
coverage is not enough.
Yeah. Okay. We're on 4.
5, any more on 4? No?
Yeah, just one little thing, the paragraph, from the, second from the bottom.
Colton Dow?
No, Chairman Gentile
that's-
stated that the board, it's the second line, it's Chairman Gentile further stated the board.
What? I don't
I
know.
don't even-
It-
Again.
You got he,
That's fine.
stated
Not on
he
the same
board.
page for me.
Chairman Gentile stated again that he wants to keep the public hearing open.
That's
He
what I
further,
thought.
he
No.
further explained to the board that he had drafted some preliminary notes
Yeah,
on findings of
That's
fact.
exactly
what
what
I
I have.
But
I don't even know where.
this is right above Mary Lou Dow at the very bottom. The
I don't have
paragraph.
Mary Lou Dow at the very
We don't
bottom.
have Mary Lou Dow at the
Oh,
very
wow, so
bottom.
these are all,
I suggest we get new copies of this and start going through this.
They should be all the same.
Well,
They're not.
They're not.
Well, I
They're not.
didn't just
Well,
change them.
I know you didn't, but
They're
These
not.
people don't have them.
So here's
I've
what I
got-
suggest that we do for the April minutes. These are April minutes.
Yes.
Yeah,
You print 5 copies of them so that
Okay.
they're
Stick 'em
all
in our
printed
box,
from the
yeah.
same printer.
yeah.
Yep, because
Okay.
they're not the same, we can't
No.
do this.
Yeah.
I'm gonna just scratch these.
Well,
Can
we'll
I
just
see
defer.
yours, Jennifer? I'd like to see yours, though.
Well, they're the same,
I know, but I
we
wanna
have the
see 'em.
same one,
I
she
wanna
has a
see 'em.
completely different one, he has a different one.
You want me to give you mine?
Because everybody told me last month they didn't have these, so I just wanna double check.
I had this from last month, I kept this from last month.
At the last meeting, you told me you
Oh.
didn't have March and April minutes.
No, I didn't, and you gave them to me in,
Did I give you
in,
The packet,
Yeah.
right. So I wanna see what the heck's going on.
agenda?
anyway.
I'm sure you
let's-
did.
All right,
I have to
anything
figure out what I
else?
did with it.
Okay.
So,
You can have it.
so we're gonna do those next week.
Yeah, we're gonna defer them
We've got-
until, July.
Yeah. Note to all, I will not be here in July, I
Okay.
will be in the UK.
The other thing is we have to do an election of the, Kate, you ready?
Yep, these match everything
Chairman
I
and
have.
vice chairman?
Those match what I have right in my hand.
Well, Sharon's don't. So, anyway, moving on.
Hers matched what I had. She said she didn't have mine matched, so mine, hers does.
Okay,
Yours?
so, okay, let's move on to, we'll figure that out. The election of chairman and vice chairman. Drew, I nominate you to remain as chairman. Do I have a second?
Second.
All those in
Hold on,
favor?
I didn't even take a motion.
Aye,
You gotta give me a minute. It's getting crazy.
I'm the one that needs a minute.
So Sharon,
We got
I
it all,
need the minute. I gotta type all these
we
things.
got it all on video, you
So
know?
Sharon made the motion.
Yep,
Who seconded?
George seconded.
and we all
Joy
aye.
stay.
Well, we have to do a roll call vote. We
Oh,
can't
yeah,
just vote.
we do, of course, because of Drew not being here, of course. No, I get it.
Oh, yes, so it'll be,
Can you vote on yourself being the chairman? Yeah, vote. Go
I
ahead.
don't think you do, they don't. They don't.
They usually
anymore.
don't, but he can.
He just did.
Okay.
Alright, roll call. Drew says aye.
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 Aye. Okay.
And,
Now
And then a
vote.
vice
and
chair?
I move to make Sharon vice chair.
I second it.
All those in favor? Roll call vote? Drew?
Aye.
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 Okay. We have to do the third reading of the revised rules of procedure. They were in the April minutes. I'll quickly,
Last one.
I just buried mine.
this is the last reading. Okay.
Found something for change.
I just put mine in the old, I'm not fighting with that.
2 items on the zoning board's rules of procedure that need to be addressed. The board deliberated extensively on 2 proposed changes to the current rules of procedure to ensure better clarity, coherence, and alignment with modern practices. This constitutes the third reading of the revised rules of procedure. 1. Allowing appeals to be filed electronically. The board considered an update to the procedure for filing appeals. This proposed amendment would enable appeals to be submitted electronically. The intention behind this change is to streamline the process, making it more accessible and efficient for appellants. Under the revised rule, a motion for rehearing can be filed through electronic means such as email, followed by a requirement to submit an original hard copy with a wet signature at a later stage. This adjustment aligns the board's procedures with current court practices that accommodate electronic filings.
Where did that come from?
This is from your minutes.
Oh, I read them from the rules of procedure, okay.
Oh, all right, well then
Okay,
read.
that's okay,
Go
that's fine,
finish.
no, that's fine, that
Is it,
works, that works.
is it the same?
That works.
Does this
It's-
work?
That works.
Okay.
Good.
This says 1, it should say 2. Reversing the order of items N and O in
Yeah.
section 4.
Oh, yeah.
Yeah. The chair will
An
jump.
adjustment to section 4 that pertains to the sequence of events during public hearings. The proposed suggests swapping the order of items identified as N and O for enhanced procedural logic. Presently, item N directs the chairman to close the public hearing unless there is a request for continuation. The new arrangement would position the current item O, which includes the chairman's summary of the facts and claims with opportunities for corrections from the floor ahead of the hearing's closure. This revision is intended to ensure thorough public engagement and feedback before the formal closing of the hearing. The corrected sequence promotes attentive listening and responsive adjustments during deliberations.
And I'll make the changes that are actually our rules, I'll make them to this here. These are
Right,
our rules, and
because
I'll
then
switch them.
these will have to change too.
Is this a third reading?
The rules of procedure,
This
that's
is-
what I have in my hand.
this isn't the rules of proceeding, this is the case checklist thing. You'll have to move where the closure of the case is.
I don't even know where that is in the system. That was
The rules-
before I even came here. That wasn't even my form. I'll have to ask Linda where it is.
Where it is and how to change it,
Yeah, not a clue.
okay?
Okay,
Anything else?
I'm done.
Move to adjourn.
Our camera person
Se-
in charge.
Seconded.
All in favor?
Aye.
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 All right, 10:15, we adjourn.